muted. Do you want me to try to send a code to unmute it?
It says my video is muted.
Yep.
Um, sure. Let's see. Okay.
Okay, you're on, Amy and Bill.
Yep.
You're live.
Okay, sounds good. Good evening, everyone. Welcome to the August 10th, 2026 Planning Board meeting. This is the Northborough Planning Board. First on our agenda tonight is the public hearing, the continuation of the public hearing for 409 Green Street, application for a wireless communications facility, special permit and site plan approval submitted by TowerCo LLC and Cellco Partnership DBA Verizon Wireless for erection of a 130-foot tall monopole accommodating 9 panel antennas, 6 remote radio head units, and associated equipment within a 70 by 70-foot fence compound located at 409 Green Street. Welcome, everyone. Okay. I just wanted to say, at the last meeting, we were very close to making a motion. So this meeting was continued for 2 more weeks. As Millie and I had final questions, the applicant allowed the shot clock to continue to today. My plan for tonight was to start by discussing those questions, take any final comments from the applicant and the public that we haven't heard before. And then I will leave the hearing open during deliberations for the board to ask questions. But during that time, we won't be taking any new input. So since we last met, we did receive a document from the applicant. I think it came in Friday, but Lori was away, so she sent it out to the board last night. And then there were 2 letters received over the weekend from residents. Did board members have time to read the emails and the document?
Yes.
What documents were you asking about?
Oh, just there was one sent over the weekend. It came from the applicant and Lori sent it out last night. That's all that I have received. So Millie, they were the answers to your questions. So I was actually just going to ask if you had time and the board had time to read it. And do you have any additional questions?
Yeah, they actually didn't really address my specific questions. So I was looking for specific dates and communication for any of the potential or alternative candidates. And so the reply basically just gave me more details on some of the information we already had, but I was very, very specific in asking for what dates did they actually reach out to these people. And it said that they did Tugas and the Haven by email, but there was no there were no emails provided to show that the dates that they actually reached out and communicated to anybody, and I'm having a little trouble with that.
Is there someone from the applicant here that can speak to that?
Hi, good evening, Ellen Fryman. And yeah, Michael Fenton had a conflict tonight, so I am sitting in for him. And also with Scott Schwartz and Fenton. So we went through files, picked up, found as much information as we could. And because this was over a protracted period of time, so people involved, I understand that this was all that was available and that we could locate. So everything that we have is provided, and there's really nothing else that we could supplement this with. So
there's really no actual communication that we can really go by that these applicants or these other candidates were actually connected with or spoken to or replied, or that there was any type of response from them other than what you've already provided.
right, yeah, this is our testimony, and I can tell you that we're not providing anything that isn't true and correct.
I believe that what you have provided is probably true and correct. I was really just very specifically interested in the content of the communication, the, you know, the attempts that were made, the dates.
Okay, I mean, there are some dates. We have Davidian Farm was contacted in September of 23. Same with Tugas, Haven Country Club, August 23. So I think is, again, as best that could be discerned from what people have in their files from over time. That was, we provided everything that's available that is, you know, that anyone has. So
Right.
I'm not trying to hide anything. I was trying to, you know, I mean,
No, it was,
Yeah.
and that's helpful to some degree, but that the saying that it was contacted, you know,
I'm
yeah.
looking at it. Yeah, in April 2023, received searching. Corey has been working since 2022. So, again, we've furnished everything that we have. I haven't been asked to provide anything like this before, so I don't really know what is typically available.
Mhm.
So, yes, it's a new request, but, typically we just provide a chart like we did originally with the location, and then what happened with that site. So that's our typical submission. And, I would like to be able to provide that information. I know everyone would wish we could. And this was all that we could come up with. So,
Okay, I
yeah,
find that.
yeah, I understand.
Okay. Do any other board members, or Millie, do you have any more questions? Do board members have any other questions?
Do not.
Okay.
I mean,
I
I
had,
have some other questions, but not specifically related to the original questions.
okay. Well, if you want, you can ask your other questions now too.
So one of the other things that I was curious about is whether or not the date of the lease, or if there's any redacted lease documents that might be able to be provided or shown, so that we do again have a date of, what I'm really trying to get to is the order of how this whole application was, you know, processed.
I don't have the lease. Brett, do we have a copy in the file? For the date?
I am looking right now. Let me check.
This was, again, an extensive search. We've gone through the process, to find a site that works with all the parameters and all of the issues and roadblocks that we have to overcome to find a site and negotiate a lease. It's a long,
Yeah.
protracted process, and to find one that works, it's not an easy feat. So,
Yeah, it definitely seems like there's a lot of information there that has been provided, and you know, looking at every different piece of parcel is a pretty extensive undertaking. And yeah, I think
yeah.
what I'm getting at is looking for, again, what the alternative candidates were, how the process unfolded, and just the elements of timing, so that they hopefully fall in order. Yeah.
Okay. I mean, we're not involved in the leasing process, so that's why we didn't negotiate the lease at someone else, so that's why we don't always have a copy.
Mm.
Yeah, and so we did provide in the second supplemental submission, that the lease was executed in 2025.
Okay, but it doesn't say when in 2025, right? Because, I mean, Dividends was also contacted in 2025, Tugus was contacted in 2025, Haven was contacted in 2025, is that correct?
Well, I don't know when they were first contacted. No, we have 2023. They were contacted in 2023. Everybody was 2023,
Okay. Okay,
and that is in the submission that we just gave to you.
yeah, I think I saw that.
Everybody was 2023.
Okay,
And I can
Okay.
provide you with the exact date. I just can't get into my computer. It's super slow right now.
So, but we don't have a copy of the lease. We just had the information that it was 2025.
Generally, we include a copy of the lease with the whole
Yeah.
application. So that's what I'm looking for right now to see
Okay.
if and when we provided it.
So
Yeah,
that's
we
not,
do when it's a
oh.
municipal lease, but private leases, we generally don't unless they're requested, and then we redact them.
Yeah, so if I
Mhm.
understand what you had mentioned, Carrie, is that it's not uncommon to provide the lease agreement or parts of it, the redacted.
Right, and that's what I'm checking. Did we or
Yeah.
did we not? Is it part of your exhibits? I'm not sure if it is because my computer is at
Yeah.
2%.
Sure.
So no. I
Yeah.
see Lori has her hand raised. Lori,
I specifically asked Mike Fenton for a copy of the lease, and I was told that that was confidential and he wouldn't provide it.
It's not. Well, we would redact it or
Right.
we would provide a memorandum of
Yeah.
lease.
Yeah, we typically don't, but I mean, Carrie, we do applications for others, so it's something we generally don't do unless it's asked for, but we can still provide a redacted copy. We'd have to
Um,
get it. And Carrie, you obviously have it, so we could do that.
We do have the memorandum of ground lease that was entered into January 6th of 2026.
Memorandum of ground lease, what is that?
Yeah, that,
Memorandum of ground
That's
lease, like a notice of lease.
yeah, when you sign a lease, you need to record just a notice telling people that you've entered into a lease, so people searching the title see that it's subject, the property is subject to a lease, so that's generally done right when the lease is signed, so it leads me to believe that the lease was signed towards the end of the year, if this was
Okay.
signed in January. And that's a public document, that's in the I mean, was it recorded, Brett?
Yes.
Yeah, so that's in the public records, and it's a summary of what's in the lease, except for obviously the lease amount, but the start date and the term of the lease, that would all be in there.
Yeah, so based on the memorandum of lease, the lease agreement is dated February 13th of 2025. And then the memorandum of lease was finalized in January of 26.
Quite a different distance, but okay.
Okay. All right, thank you, appreciate it.
do you have any other questions, Millie?
No, I don't. It seems that that sort of follows within the order that I was thinking that the applicant had processed, but I just, again, was looking for some confirmation from the people that they had reached out to and contacted, and I really haven't seen that. So that's the date of the lease is something that makes sense with everything else that has unfolded in their application. The only thing that I really don't have is the communication with other properties, other than what they've already said.
Okay. All right, do you have any more questions? I don't know if I just said that. I'm just making sure there are no questions from the board, because the whole purpose of tonight is to get to a decision. So we have to deliberate, but I want to make sure everybody has the answers to their questions and the applicant has given all of their information.
I mean, yeah, again, I do have other questions, but I
Sure.
think that I can't see who else is on, and maybe this is something that Mike can help with. Let's see.
Bill, did you send her a link to try to open her video?
I did.
He did, and it basically said my camera is saying it can't receive it, or it's not able to open. I've had this happen through this link before, so I don't know if it's a problem with the link, or if I'm not going through Google, my other website. I'm going through the town provided website. I don't know.
Well,
But
just
it
to
just
let you know
flashed.
that, huh?
Something just flashed. Oh no, that's my Zoom link that's working. But if I try to click onto my Zoom link, it connects me from this town one, so I can't do it.
Okay. Well, there are people here tonight from Verizon or from the law attorney's office.
Mhm.
And there's someone here from the Tower Company, and Robin Stein from KP Law is here, and Mike Lawton's here. So if you have any questions, it's a similar group that we normally have on the Zoom.
Okay, so I did notice in the original application that one, or the original search, that they were looking for a 120-foot tower. And in our application, obviously, they have a 130-foot. So is that something that can be explained why it went up to a higher tower?
So, Millie, that was actually one of the questions I asked in my initial set of questions
Yeah.
to the applicant, and they wrote a response to that question. I will try to find it unless Ellen or unless you guys have
Brad
it.
might have it.
And I did read that, Mike, your response, and it basically, they responded with the terrain differences from their original ring search. Is that what I understand to be the difference between the original 120 feet request?
To be honest, I don't remember what they said. That's why I wanted to either look at it or read it before I gave you the answer. But I do remember asking the question, and I do remember there was some responsive documentation, but I just don't remember what it was. So.
Yeah.
We
Okay.
can wait.
Yeah, and we're looking for it too.
So if you look through the alternate site analysis, we went through everything that we look at. We look at the terrain, we look at the constructability, the zonability, everything else based on the search ring that Verizon originally gave us. We went through that. We knocked out conservation parcels, we knocked out terrain, we knocked out wetlands, everything else. Then we had to, and I believe it's on, I don't know what page it's on, but we show a search ring where they said focus on this bottom half, and
Yes.
it moved a little bit.
Yes,
And
it
so
did.
when, in moving it, that's what caused us to have to go up to the 135. The
Okay.
original search ring was 120. This one's 135.
Okay. All right. I just wanted to make sure I understood that correctly. Thank you.
And the 135 is, the 130 is the height, and 135 is because of the lightning rods.
Yes.
Yep. Sometimes it seems like we have 130, 135. It just, when it gets to the end, I want to make sure we have the right numbers.
So I think that was one of my questions. In the property itself, and I don't know if somebody can pull this up, because obviously my screen sharing thing is probably not going to work because I can't see what I'm doing. Is where the tower is currently located, or proposed to be located. You know, there is a stand of trees that is partially on the existing project property site and partially on the abutting property site that when I was driving by, I thought, well, can you place that? If somebody can pull this up, they might be able to see what I'm talking about. You know, can you place the tower just behind the trees? So it's not so obvious coming up on Ball Street and it's partially hidden. It doesn't seem like it would really affect much of the current waivers, which are for property lines and setbacks.
Do you have the site plan, Lori? That you can pull
I,
up?
I can pull it up, but I did want to mention that the cell tower is sited behind the trees with the view of Green Street. So it's impossible, in my opinion, to site it behind the trees to obstruct the view from Green Street and Ball Street at the same time. So they chose to obstruct it from Green Street. So, but let me,
Well,
get the
I don't
comments.
know, because I drove there and I just was curious as to, because coming from Green Street, there's a bit of a shrub and embankment that sort of elevates the property. And then you have the greenhouse that sort of hides things. And then it just wasn't as clear to me that the open vista field in front on Ball Street is significantly more visible.
Lori's working on pulling it out.
Yeah.
Lots of
I don't-
exhibits.
You know, obviously I don't have any measurement of feet, but it doesn't seem like it would be any different than the property that's closest to the house. It would certainly be closer to the greenhouse, but the you know, the criteria is for residential property is what? I forgot how many feet. 400 feet, I can't remember.
I think 500 feet.
500, but it's obviously residential is different than the greenhouse, so I don't know if this is designed to collapse in on itself. Whether that was considered an option, and you said that they chose to go to Ball Street, which I think is a far more open view.
Brett, is there any way you can pull up the exhibit? Because it's really difficult for me to see because they're just numbers, lettered exhibits. So I can't find easily the photo simulations. But probably you have them.
Yeah, I'm pulling it up.
What do you want us to show you?
The photo simulations
Right.
show
from
that
which
show the
perspective?
views from Ball Street versus Green
Okay.
Street. The ones that I'm talking about are the ones with the crane test. So I think they're in maybe the second supplemental.
Yeah, I have them here. I can share my screen. Can you see the screen?
Yes.
So this is the Ball Street
Mm-hmm.
view. This is Ball Street as well, right in the corner.
Mm-hmm.
Let's see.
So what you're asking, Millie, is if it could switch to the other side of the trees?
Effectively, yeah. that again, it's obscured by the house. There's not a large span of distance between what I would call, tall shrub. There's an embankment. It was more obstructed from that. To me, if it were to be moved on the other side of that stand of trees, I believe there's one more view. This is corner of green. If you go to Ball, I don't know what photo number it was. Not Ball, I meant green. Sorry.
Just so you know, Millie, that will
There.
impact the setbacks from the property lines as well as the nearest residential structure. I mean, it could be better, but it could be worse.
I agree, but the property line, as we have been told, is the same owner. So there was a reason to, they use that as a reason to maybe give a little bit of lenience on that. And the residential there's a greenhouse in between the residential and what would be there would be no direct fall onto and they said it would collapse. So I don't have the numbers, but
But if you put it on the other side of the trees, then it'll be closer to the residential abutter on Green Street. So if you put it on the other side of the trees, so
Yeah.
if you move it
yeah,
further, then of course the view will be wide open to Green Street. And I'm not sure how close the residential abutter is on Green Street. So it could be closer, it could be further away. I'm not sure because I haven't looked at that.
the
So we did,
residential
I mean-
abutter is the same property owner.
I'm talking about the residential abutter to the north.
So on the other side of the road?
And also there's another abutter that's off the page to the north.
Yeah.
So
So you're
the,
saying
the
that's closer than their
residential
house?
to the Davidians. So I'm not quite sure. I can look on the GIS.
Well, they have the residential abutter there as 275 feet. Obviously, that's their own property, but if I'm not understanding, I don't know, maybe I'm not understanding this correctly, but Davidians is
If-
basically surrounds that piece.
If I may interrupt,
I'm sorry,
and
yes.
if I can have permission to speak, I don't know. So as part of our alternate site analysis, we explained how we go about picking sites.
Mm-hmm.
So part of that is looking at the topography, looking at the parcel, what is the best spot for it? And we realized we needed setbacks, but we picked the spot that we picked based on elevation, based on topography, based on access, based on the landlord's preference of not interrupting the operation of their farms. So we picked that spot based on all of these factors. So I don't know, I mean, we can contemplate trying to move it, but we would have to look at all of that all over again. And I believe we already did that.
I would
We-
say that we already did that and that we determined that this was the best suited site for it, given all the other factors that we had to consider.
So
Yeah.
I did actually, if you unshare, I can share my screen, which shows what I was concerned about. So there is a couple of residential abutters to the north. There is 445 Green Street, and then there's also 440 Green Street. So I did a quick measurement of, just seeing, well, what if we were to move the cell tower to the edge of this property line?
Mm-hmm.
And that house would be 604 feet.
Which is greater.
Approximately, this is GIS, so it's
Yeah.
not precise. And the other residential butter to the property line would be 564 feet. It would be closer, of course, and further away from the home. But I did want to, I'm just gonna put the aerial photo on there. So what you'll be doing, well, actually, I can see here that the other side of the trees is actually on the APR land.
Right, I
So-
know that.
So you can't put a cell tower on
Right.
APR land.
Right, I know that. I was saying just wherever it is on this parcel, tuck it behind, the trees that are still there, that are there. And that to me would be more, more obscured than the current position that it's in, which is a wide open field, all coming up Ball Street. And this is a bit more tucked in, and I hear what they're saying about they did terrain, they did a certain preference of the property owner. But I think those things are negligible to some degree compared to the maybe the benefit that might be that might be gained.
I guess what I'm pointing out is if they put the pole where my finger is
Yeah,
pointed,
no, I'm
then
not.
you're
I'm
on the
saying,
APR
right,
property.
right. No, I'm saying keep it on the same property. Just put it right on the other side of that little cluster of trees that's coming out. The little,
Like here,
keep
is that-
going. Yeah, go behind the trees. There's an empty space. Just, just move it.
there's like a one single tree here. Is that what you're saying?
I don't know if it's one or partial of one and part of the other, but it's at least more obscure than what yeah.
Excuse me, Carrie had she got kicked out. She is waiting to get back in. I don't know if you could let her in, please.
Because
She's
you
here.
could put that right up on the property line if you wanted to, couldn't you? The fencing? It's the same property owner, so can't you put the same, can't a
I don't know, we have to look at the site plan and see what else is there and why we wouldn't have done that. Had to be some reason.
I'm just gonna bring up the street view so that you can see what the actual view is close up to the trees. So there's the grouping of trees.
So I'm saying
So
going right about
are
where
you
you're at.
saying you want it to be put just in the middle of this grouping of trees? Because I would think that they would have to clear some trees to make that happen.
I don't know if they would. I don't
Well,
know.
you need a 70-foot by 70-foot fenced in area for all of the equipment, the ground mounted equipment.
Yep. And so, again, I'm not an architectural engineer here, but just looking at what they've got for the square on the photo simulation, it seems like it would fit if you were able to put it right up against the property line.
Yep.
It would be close, but I don't know that it would be impossible.
Carrie, get back on.
Yeah, she's on.
Oh, okay.
We have to look at the site plan and see what that entails and why we wouldn't have put it there to begin with.
I mean, if it's, I know what was mentioned was the, again, the landowner preference. And again,
Well, we also try to comply with the setbacks to the greatest extent possible. That would be even more, non-compliant. So, I mean, again, we would have already looked at that and there has to be reasons why we selected the location that we did. I don't know that it's going to affect the visual impact that much, but there are reasons why we selected that spot. So.
okay.
And they've been outlined in that alternate site analysis We've given the elevation of our location and why we need the 135 feet because of that particular spot. And my assumption is, and I'm looking at it right now, is that the elevation doesn't work, or that the landlord said, hey, I don't want you to interfere with this part of the operation of my business.
It does look like there's more interference with the operation. It would look way more intrusive where it was, where you're proposing.
Hmm.
One thing I was gonna ask, and I don't know if it's the right place, and I don't even know if it would help what you were thinking about, Millie, but there is the clump of trees to the right, and we had talked about street trees being planted. Could they plant the clump of the pine trees to the left of it, right on the corner? That, you know, I'm sure they won't be big now, but they would grow. So then there'd be another clump of trees on that side. So as you came along Ball Street, you know, in the future, it might help a little. I didn't know if that was something possible.
I think
I
we
know-
did discuss that.
Okay. You could or you did?
Yes, we can do that.
Oh, okay. Yeah. I don't know if that helps you, Millie, at all, but
As far as, I'm sorry, trees along Ball Street or trees along?
well, we already had a condition that we had discussed, and I'm not saying which way, you know, anyone's gonna go, but one of the questions I was gonna ask is if there could be a grouping of pine trees being planted to the left side of the cell tower that would grow up over time, either at the top left corner or at the bottom left corner of that property. So it would have a buffering over time along with the street trees.
I mean, I guess that, those are conditions, they're options. I'm not sure how compliant people are with some of those, but that's a different.
Right, it was
you're
something
saying-
different. But while you were
Yeah.
talking about it, I figured I'd bring it up that it was one thing I'd thought about.
Yeah, okay.
Yeah, we talked about, landscape plan depicting installation of street trees along the property frontage, 321 Ball Street, 351, 409 Green. So, yeah, so there are some conditions that you had asked that we consider. So, I mean, we'll have to work with our landlord and make sure we're not disturbing operations, but we're willing to, consider putting in some of that screening.
Yeah, on the property at 409,
Yeah.
just on the, what is it, the west side? Yeah, west side. Okay. Do you have any more questions, Millie?
I feel like I do, but sorry, uh, wasn't really prepared to be the
It looks like
main
you're on the,
speaker.
got all the
Right out of
questions.
the gate. Uh, I can't say, oh, I do actually have some questions, sorry, about co-locators. Um, i- if I understand correctly, co-locators can be, at the same height on the same tower. Is that correct?
No, they have to be 10 feet apart, I believe.
They can be 10 feet apart horizontally or 10 feet apart vertically. Is that correct?
Vertically.
But they can be horizontal.
Well, each carrier has their own array on the tower. So they would need 10 feet in between the spacing of each array vertically. So I don't know how.
That's not what I understand, but that
Mm.
you can put more than one co-locator at the same height on a tower. So,
I've never heard of that.
okay. Is that something that Mike, you can chime in on? Or is that, am I completely wrong on this? Hello?
I'm sorry. Yes, I'm here.
Yeah.
So they putting more than one commercial wireless carrier at the same height on the tower is technically very challenging. I wouldn't say it's impossible, but it's darn close to impossible. Most of the way the towers are operated, the commercial wireless carriers would lease a particular level and mount their antennas at that level.
I've never been
Okay.
asked to permit anything like that in 30 some years.
So it's okay, so it's doable, it's not preferable or recommended.
I've
I'm not
never
sure.
seen it happen.
Well, I mean, I think the comparison would be, or the opportunity for something like that would be on a rooftop where you have hundreds and hundreds of horizontal feet, and you can have
Mhm.
carriers separated
Um,
horizontally significantly. But
Okay.
if you're talking about a tower where you can't separate the antennas horizontally, it's not a reasonable thing to
Yeah.
try
Okay.
to do.
Okay,
I'm in agreement with that.
okay, thank you. I think that's it for me.
Okay. All right, the board members, Anthony or Bill, have any other questions?
I do not.
I do not.
Lori, do you have any other questions? And did the applicants have anything else to add? I'm gonna go
Amy?
to public comment since it's a public hearing, but I just want to ask board members, staff, and the applicants first.
No, thank you for your careful consideration and the questions. We always welcome and are willing to answer any questions. So thank you for that.
Okay,
Appreciate
thank
the time and effort and detail that you've afforded this application.
I am gonna go into one thing real quick, I think, is that, and Lori, maybe you can, I don't have the wording right in front of me, but the scenic road protections and bylaws that we have in our town, is that something, Lori, can you perhaps pull that up and read that so I have a fresher,
The scenic road bylaw only pertains to the removal of historic farming walls and street trees within the Green Street and Ball Street rights of way. So it doesn't pertain to anything that's on private property.
but there's another code in the town, and I can't put my fingers on it, that does describe the purpose, function, and the intent of the scenic road protection. I'll see if I can find it.
Okay, while you do that, we'll take public comments. I see Susan Satori with her hand raised. Can you just state your name and address? You're muted.
Hi, good evening.
Hi.
Susan Sartori, 465 Green Street. What I think Millie might be talking about is that there's something in the bylaws in regard to aesthetic quality on the scenic roads. It's not just about stones and trees. But you did receive, and I didn't hear you say anything about it, you did receive a memorandum from a bunch of the neighbors. But you made no mention of that. Did you not receive it? Some of you did acknowledge that you had received it. So, Amy,
Oh, yes, we did. That was one of the emails. Like I received one from Sharon Berube and the other one was from Barbara Hopkins.
well, it's a 31-page memorandum, and it's respectfully submitted from 10 households here. So I think it's a fairly substantial communication, and would appreciate the acknowledgement of the time and effort that was put into doing that. I want to speak to you in regard to this aesthetic quality on the scenic roads. The federal courts have held up adverse aesthetic impacts, and they find it as a valid basis for denying wireless facility applicants. There's in the memorandum that was sent to you, there's documentation in regard to case study that shows you indeed that this is a true fact. But we've been told time and time again that that we do not offer anything other than emotional complaints and issues. So we took the time and effort to put together this memorandum and certainly documented it with court cases and everything else. We've given you an awful lot of facts. And I've been told that you would not accept photos from us, only from the applicant. So I find that disturbing that you,
Not
because
sure who said that.
Lori,
Oh, I didn't.
No, that's not true. Every single photo that you provided to me was shared with the planning board and the applicant.
well,
I never
originally,
at one time said that
may
I
I
would
speak,
accept
Lori?
photos.
May I,
In
may I
fact, I
speak?
can provide proof that I forwarded all
Sure.
of that documentation.
That's
And
great to
They
hear.
are listed in the exhibits.
Good. That's great to hear because when I said I wanted to send them, but I still did because I'm just that kind of person. I didn't know where they went to and if anybody got to see them. But I think it's important for you to see those kinds of pictures and take note of them. The ones that were brought forward from the applicant are off from the street and they're not on the properties. This is a unique neighborhood where a lot of people sit on acreage. I mean, we're we're actually zoned in such that we have 2 5 acres, 10-acre plots here. And so many of us sit way back, but we might sit back and be very adjacent to the agricultural properties, but we still can see what's going on there. And many of us have enjoyed that scenery for many years and have built a lifestyle around it. And now there will be a tower there in the center. So I just don't understand how your legal counsel did not have you address or look at this issue. I'm wondering if we really had the right kind of counsel helping with this application, where they really understood the law in regard to cell towers and where and they should or shouldn't be. I mean, I want you to know that the adverse impacts of the aesthetics would seriously impact the value of all the residential property in this area. Probably mine alone would be an impact of maybe a 15% decrease in property value. A person my age isn't going to live here for a lot more years. So, we're looking forward to selling and moving someplace else where we could use the money to have a smaller kind of lifestyle, or we're planning to leave it to our children so they can use it to benefit their lives. So to hear that you're going to put something in this aesthetic area where the court will hold up the decision on that alone, let alone some of the other things that that memorandum brought forth. I think it's a shame. I want you to understand, I live on 8.9 acres of land with my husband, brought up my children here, have been here since 1990. The house was situated on the lot so we could overlook the fields. Now you're going to put a tower there. The deck is out back, the pool is out back. Every single bedroom in this house, this 2-story building. What you're allowing them to propose is close to a 30-story building. It's going to be looming in that open field, and we're not going to miss it when we're going to bed at night, when we're in the kitchen cooking, we're on the back deck, when we have people over. Our lives are changed immeasurably. And there are other people that abut that and see it, but they are more fearful to come forward because of the dynamic of the neighborhood. So I'm here to say, I really wish that you would take into account, and I hope some of my neighbors will speak to some of the other issues that were brought forward. But if all of us up here, and I know they're substantially large lots and large homes, they're assessed at very high values. If we all go for an abatement, I'm pretty sure if they're granted, you're going to lose a lot more on annual tax dollars than you will in a $10,000 to $20,000 potential legal suit. I think it's very, very upsetting to think that you would be so afraid and be so bullied by the new person in the neighborhood, the cell tower and tower company people. It's just a shame, and I think we're all disappointed. But I think you should think long and hard about what's in that memorandum. It's a lot of important details there that can give you a basis to get through this. And we, the neighbors, will be here for you and be here with you if you make that choice. And so thank you for the time.
Thank you very much. I did read it. There were a lot of letters from abutters, and there were letters from local realtors that talked about the loss of property value, that less people will look at a house with the cell tower nearby. So I didn't mean to say that I didn't read it, and I'm sure other board members read it. Is there anyone else from the neighborhood or anybody else, from the public that would like to speak? Barbara Hopkins, can you just say your name and address?
Yes, thank you. Barbara Hopkins, 335 Green Street. Thank you for the opportunity to speak. Back on June 25th, I sent an email to the planning board with several questions. I received a reply, so thank you for the reply that I just received just this afternoon at 2:45, as well as subsequently at 3 p.m. from the building inspector, Bob Federico. So I will promptly respond in writing. For the purpose of this conversation right now, I do want to go on a record with a couple questions. Since the building inspector, Mr. Federico, stated that the existing 2 poles currently located at 351 Paul Street, that the use of those poles is currently prohibited, and there are several open items that have not yet been satisfied to allow the usage of these poles, while at the same time the planning board has stated that these poles serve Boylston public safety. My question is any equipment on the pole currently operating? And if so, under what authorization? And a couple other questions, and that is, the bylaw permits a height waiver only in exceptional circumstances. What exceptional circumstances do you find in this application and consider them to be exceptional? And then last but not least, I would like the board to confirm, and I will forward some other questions, but that I would like the board to confirm that the requested, because this showed up in the email, that the requested 130 feet tower is being justified solely by the Verizon's commercial coverage needs and not by any findings that Northborough Public Safety Communications require a tower of that height. Thank you.
Thank you. Sharon, can you state your name and address?
Sharon Berube, 359 Green Street, Northborough. I just want to follow up on a couple quick items. We've all discussed it. I'm just reiterating. This application violates the Northborough Code. It's inconsistent with the character of the neighborhood in the master plan for the town of Northborough. Adverse impact, absolutely. We have letters from local realtors reducing value, can be anywhere 10, 15, 25%. So potentially we're looking at a 15-story tower. You know, the 130 initial, 20 additional, That seems like it's automatically granted after the fact. I think it's a Spectrum Act. I just can't even wrap my head around how much discussion there has been to even entertain this application. It's been stated there's a significant gap, but yet truly not the data to back that up. Has anybody really examined that? The data is lacking in backing up a significant gap. No test drive data has been shown. Again, you pull up, I did double check this, you pull up the Verizon coverage map, it does not show a gap in this area. And I know Mr. Fenton said, well, it's for marketing purposes, or Mr. Lawton might have said that, I'm not sure exactly which one. Irregardless, it's what Verizon represents on their website as far as coverage. It does not show a significant gap. In these maps, they show they tested 2 frequencies out of 10. What happened to the other 8 frequencies? I think it's been discussed in a meeting that, you know, if 5G isn't available, it goes down to 4G, etc. So they've only tested 2 frequencies out of 10, and that's what they're basing their information on. It is incomplete information to prove that there is an actual gap. I think I'm just looking through my notes real quick. I believe they tested the frequencies, the propagation map showed 7,100 and 2,100. That's it, no others. The majority of the country operates at a negative 85 dBm. This application, I believe, is for a negative 98. That's 1,600 times higher than other places in the country. Why do we even need that? There is no good answer because we don't need it. So I would, you know, I do believe they picked this location because it's the cheapest. But I really think the town, the planning board, we've provided you with factual information that holds up in court. I know you've been running scared that you're going to get a federal lawsuit. Well, maybe it is time that the planning board sticks to their bylaws, doesn't issue these waivers, and has a backbone for believing in what our town is trying to stand up for and abide by our own bylaws. So that's all I needed to say, had to say tonight. I just really hope you seriously think long and hard, because the evidence isn't there that there is a significant gap. We have the aesthetic issue and the lack of due diligence. I don't even know how we're still talking about that. That is a reason for denial right there. I can't believe that they literally knocked on the door of 4 places. That is not due diligence in finding a great location. I mean, I could pull up, you know, acreage tucked in the woods in this area and give you a list of 10 of them right now. Were any of those people, did the doors get knocked on any of them? I doubt it, because all we've heard of is the Haven, the town of Boylston, Tugis, and Davidian. So I myself would not consider that due diligence, but I think it is lacking in their grasping, to say the least. But that's all I have to say. Thank you.
Thank you. Mr. Lawton, would you mind speaking to that? I think we've asked before that, you know, the plots
Sure.
or what they look at to prove significant gap, and you reviewed them.
Yes.
And I just want to get your opinion on that.
Yeah. So, I mean, what we've been provided by the applicant and through some follow-up questioning is very typical for the plots that we see in many, in fact, most other permitting cases in Massachusetts and throughout New England. The representation of 700 megahertz and 2100 megahertz as sample frequencies for coverage is typical, and is something that has basically I've seen, or in every Verizon application that I've looked at, throughout Massachusetts over the last several years. So it's not unusual. Also, the point was made that a larger negative number was stronger coverage, and in fact, that's not correct. A larger negative number is weaker coverage. So the applicant is proposing coverage to a lower standard of coverage in this case than the -85 that was referred to. So to be more specific, -85 dBm is stronger coverage than -98 dBm. It's not weaker. And the final point I would make is there's been a lot of sort of fuzzy math about the height of the tower. The tower is 130 feet. The typical height of a office building is 12 feet per story. So if you're going to compare the proposed height of the tower to a building, it would be somewhere in the order of 11 stories, not 30 that's been stated here.
Thank you. I'm not trying to downplay what anybody's saying. I just wanted to hear from the our peer reviewer just to follow up some of the questions. I see Larry and Kristen Blanchard. Can you please state your name and address?
Yes, Larry Blanchard, 366 Green Street. Just a quick follow-up with Michael Lawton. Michael, could you just give me a sense, do you have actual hard data in terms of a drive study throughout the entire area affected? Do you actually have a report on that? I wasn't able to find that.
The applicant has not been asked to provide drive data in this instance. Typically, there are some jurisdictions in Massachusetts that require drive data as part of an application. Cape Cod Commission is one of them. But typically, I would say by and large, most town codes do not require drive measurement data. Or drop calls, which were mentioned here. And the other portion, from an engineering perspective, what engineers typically look at, and I know there's a lot of rhetoric out there that that talks about, you know, gold standard of drop call data and measurement data, but drop call data and measurement data is a very skewed view, because if there's truly no coverage in a location, you can't have a drop call because you can't initiate a call. So what I'm saying is, typically if the town code requires measurements data, applicants will provide it as they do with the Cape Cod Commission. But the town code here does not require measurement data. So we reviewed extensively the plots, and I asked for some additional plots, propagation plots, and which in every case that I've been a peer reviewer on in Massachusetts and throughout New England, I've always asked for additional plots, because the initial plots that are provided are often missing a few things. And we got an improved set of plots, and I looked at them. I find, in my professional opinion, that the plots represent as realistic a view of the current coverage situation and the proposed coverage situation as we can expect to see for this proceeding.
Ken, and I understand, and again, you're the expert on this. That's why I'm asking you, though. And what I was told is that the current data that we have in terms of gap study is software generated data, and that is not as accurate as drive study data. Do you agree with that statement?
I would agree with the first part of the statement, but not the second part. The first part that I would agree with is that what is being provided here is propagation modeling based analysis, which is done using similar propagation tools to what the carriers use internally in their office every day. The RF engineers of the carriers at the carriers' offices are trying to simulate the coverage, improve the experience for the customers. And so propagation tools are heavily used within the industry. Drive test data is not necessarily more accurate. In fact, it can be in some cases less accurate and is only done in cases where there's a very specific requirement to do it. For example, if a tower is being potentially located in a particular area where it cannot be above a certain height for FAA reasons, because it's too near an airport, a carrier will simulate that coverage to see if that site is even worthwhile at a given height by putting up a carrier wave transmitter to see if that site will cover what they need to cover. Also, if it's a particularly expensive site, carriers can simulate using measurement data. But the statement, and I'm fairly certain I know where you've heard this, but the statement that measurement data is more accurate than propagation data is an incorrect statement.
Okay, and the courts would agree with you on that? Because
yes,
I was told contrary to that. So
courts would agree with that. Courts have reviewed plots like this. In fact, I think most any judge as a legal professional would defer to the RF engineers to advise on what they would use. And that's what you have sitting in front of you right now, telling you what in 35 years working for carriers, what I used to make my decisions. And that's propagation prediction data. I know there are some attorneys out there that like to call that into question, but remember, they're not our RF engineers. They're not trained in RF engineering, and they're not experts in RF engineering.
all right. Well, thank you.
Okay, thank you.
That's the danger.
John Cogswell, please state your name and address.
Yep, John Cogswell, 483 Green Street. Just a couple quick notes. I'm trying to stick to things that maybe haven't been discussed before. One of the last meetings, the issue came up of public safety and the fact that public safety had communication issues, and this tower, it was alluded because it was brought up in the meeting that this tower was going to somehow solve that problem. And I just don't think anybody's made note of the fact that that was a pretty specious, call it indirect claim, call it what you will, pretty specious claim. Because in fact, it's, from my understanding, it's handheld radios and those kind of communication devices that they need to invest in. So just want to make that point because I don't think they justly got called out on that. Precedent for waivers, this is not one waiver, this is two waivers. Just very concerned about, what's the precedent for waivers? So now what's going to get built next in town when somebody applies for a waiver or two in an area that obviously it needs a waiver, it's inappropriate in that area. And the final thing I guess I just would point out, and it has to do with the aesthetics and really the economic engine of this particular area of Northborough. It's really this is a scenic recreational area. When we moved up this way in '96, I was surprised at the volume of people on the roads. This did not include Bill getting lost, but people were, come by on bikes, motorcycles, hike, walk. Pisgah's obviously very active. The farms are as well, whether it's the farm stand or the pick your own farm up here. And so it's an area that's always attracted folks and activity from all over. And again, I would just state that I think it's a true economic engine for Northborough. So it's unfortunate the thought that this, again, inappropriate industrial structure would be put in this environment. And we mentioned this in our letter to the board. Think about the state of Vermont. And I think if this is approved, it's akin to billboards along the highways in Vermont. It's just totally inappropriate for an area that's really enjoyed by so many people from a recreational point of view. And not to mention residential area A, which are the least favored areas in town, according to the zoning bylaws, for installation of this kind of facility. So thanks for listening, guys, and appreciate all the time you're putting in too.
If I may, one comment on the first statement you made, Mr. Cogswell, about the public safety, and I do agree with that. The idea of the public safety requirement or the public safety being improved by this tower is a long-term future potential. Coulda, shoulda, woulda, maybe might happen. It's not to my understanding and from everything that I reviewed, the town of Northborough Public Safety doesn't have the funding or the intent to place anything on this tower anytime soon. So the problems that were documented at the select board meeting with the town's public safety system are real and exist, but they're in a different part of town than what we're talking about here. They're down closer to Northborough Crossing and the old hotel that used to be on the south side of Route 9 on the Shrewsbury border, which is where the documented issues exist. And this tower would not resolve those in any shape or form.
Okay, thanks. Larry and Kristen Blanchard?
Yes, Larry Blanchard, 366 Green Street again. Michael Lawton, just a quick question. When I looked at the filing for the tower, which was very specific about the equipment that was going to be on the tower and its height and size, et cetera, does the fact that we're now going to transfer the equipment from the other two towers on 351, I believe, Green Street or Ball Street to this tower, does that change any dynamics of the design of the tower or the filing requirements of that tower?
Well, to be honest, I'm not sure that there's a specific plan of what would be transferred over, other than that the applicant has committed that they will support the needs of Boylston and potentially future needs of Northborough Public Safety. But without a particular bill of materials or specification as to what antenna was needed and at what height and what radios and what cabling, it's really impossible to say.
Well, and I appreciate that. Also, do we know that the tower or the telecommunications company that's leasing the current tower for Boylston, do we know that everything has been resolved with them? And do we know what the timing of that is and those kinds of things? Is that likely to happen immediately? Is that likely to happen in 6 months? And you might not know the answer to the question. It's just a curiosity.
I mean, I've heard anecdotally, as we all have, that Boylston is using has antennas and equipment located on one of the two poles that exist on the Davidian property. I don't know what that equipment is. I don't know if it's currently in use. I don't know what this. And the only other thing that I can say about that is that through this proceeding, the applicant has committed to removing those two poles and moving whatever equipment that's on them that's necessary for public safety over to the proposed new pole. But I'm not sure anybody on this Zoom call or whatever kind of call it is has any idea what that equipment is and whether Boylston is even still using it.
Well, and that's why I asked the question about what does that do to the structural integrity and the design of the tower?
Right.
And thank you for your, I guess we don't know, but thank you for that.
And I had one quick question on that while we have it here. So there is confirmation that should Boylston not agree to move, or if the tower, whoever owns the tower on 351 Ball Street will not take it down, we had been told in the past that this cell tower won't go up. That's what Attorney Fenton had said, like this all hinges on all those pieces falling into place. Is that true?
We still have to figure all that out. We don't know yet, but we've agreed to remove those towers and move the equipment to our tower. We were approached by public safety, so they did. So whether it's, not now, in the future, we have agreed to allow their equipment on. So maybe they are thinking down the road, but they did approach us.
Okay, I just want to guarantee, because maybe Attorney Stein can look at the condition, but when we first discussed this, it was said that if this goes in, those definitely come out. And Attorney Fenton had said if they don't agree and they don't come down, then this one won't go up. So I just want to make sure.
We can look
That's correct. That's correct.
Mm-hmm.
Yep.
If we can't abide by the conditions that you give in terms of taking down the other two towers and getting the other people on the other tower, then correct. Attorney Fenton stated it correct.
Right.
Okay.
But the equipment, what it is, as stated, it is something we still have to find out.
Mm-hmm. Okay. And then while we're discussing this, I'm not sure which way it's going to go, but Attorney Stein, can you just review the condition and make sure that it has, teeth, that's what's really going to happen. And next on the agenda,
there were two proposed conditions. Oh, did you want me to talk about those or no?
oh, sure, you can. I just wanted you to at least review them to make sure.
I don't have to. Sorry, I thought you were.
Yeah.
But I can tell you what they are. I thought you were asking me, or I don't need to, though. It's up to you.
Well, in your opinion, if those conditions were to be put forward, does it state that they cannot go forward unless these two towers are agreed upon to come down?
So there are two conditions that relate to this issue.
Mm-hmm.
The first condition says that prior to the issuance of a building permit, the applicant shall submit for planning board review and approve. Oh, sorry, I'm on the wrong one. So it's prior to, hold on, here we go. Prior to the issuance of a building permit, the applicant shall provide copies of written agreements with all applicable parties or other adequate documentation that it is authorized to relocate the town of Boylston's existing public safety telecommunications equipment and the Davidian Farms existing telecommunications equipment, all ground and pole mounted equipment, from 351 Ball Street onto the new monopole and the property, and remove those existing two monopoles from 351 Ball Street. So before they pull the building permit for the new pole, they have to provide the documentation that they have the legal authority to relocate the equipment and to take down the poles. And then there's a second condition that says that within 90 days of the issuance of a certificate of completion, the applicant shall relocate the town of Boylston's existing public safety telecommunications equipment and associated ground mounted equipment to the new pole and to the property, and shall remove the existing related monopole from 351 Ball Street at no charge to the town of Boylston, and the applicant shall provide the town of Boylston with access to the metered power. And then there's another similar condition that says within 90 days of issuance of the certificate of completion, the applicant shall relocate the Davidian Farms existing telecommunications equipment and associated ground mounted equipment to the new pole on the property, and shall remove the existing related monopole from 351 Ball Street at no charge to Davidian Farm, and that the applicant shall provide Davidian Farm with access to the metered grid power. So one of the things that I think the board discussed with the applicant at a prior meeting was that the new pole needs to be built before they can relocate the equipment. They can't have a breakup in service. So the best that we could do, what we put in, was that they're going to provide documentation that they have the legal authority necessary to do this work before they pull their building permit. And then within a certain amount of time after building the pole, they will then actually go forward and move the equipment and take the pole down.
Okay, and what happens if they don't do it? If they don't do it, I know we contact the building inspector and then they would either.
Then zoning enforcement action can be taken.
Mhm.
So they'd be in violation of the permit, and then the town could take zoning enforcement action against them.
Can there be something added to the bond, like saying that they have to take it down, or then the bond for like this amount of money would be used to take it down if they don't? Just kind of like the other one?
I mean, it's something you can talk about, but you would still need permission of Davidian Farm to go on their property. And I don't know that the town would want to be in the position of actually having to go do that work and be responsible for doing that. They wouldn't be able to relocate the equipment without TowerCo's permission to put things on their pole, and I would be very surprised if the town would get that. So, the bond isn't just about the work, like the money to do the work, but it's about having the legal ability and capacity to do the work.
Mhm. Okay, I just want to make sure that it has teeth, that it will actually be done.
I think it has all the teeth it can have, which is why we built 2 steps into the process, right? Before you can even pull a building permit, they need to show you that they have everything in order to do it. And then there's a time frame by which they need to do it. But again, they can't take the old equipment down and take the old pole down until they have somewhere new to put it. So
Okay.
those conditions were written up based off the conversations the board had with the applicant at the last meeting.
Okay. Lori, I see your hand is up. Thank you.
Yeah, I just wanted to also state that there is a draft finding of fact that says during the public hearing, the applicants represented that they will remove the telecommunications equipments and monopoles on the abutting property at 351 Ball Street and co-locate the telecommunications equipment on the proposed monopole at 409 Green Street. The applicants acknowledged that they can only construct and use the proposed monopole if this is done.
Yep. I think it's great, but I don't know if findings of fact have any teeth. So that's why I was just making sure there was some teeth. Barbara Hopkins, could you just state your name and address?
Yes, Barbara Hopkins, thank you. 335 Green Street. So on the same topic of the 2 existing 75 feet poles, as of 3 p.m., and this is Larry to answer your question as well, as of 3 p.m. today, per building instructor Bob Frederico, I quote, "A final inspection was conducted and several items need to be addressed. The permit is currently open and the use of the pole is not allowed until the project has final closeouts." So this is now my comment to Ms. Stein, who just stated that there would be a risk of the interruption of service to Boylston. If there is currently service provided to Boylston, then it means that there is an active violation according to the building inspector. So we have to decide whether we are currently in a violation or in fact whether the equipment is currently not being used as instructed by the inspector. And here is now my follow-up couple questions. Question number 1 is if in fact the equipment is operating and therefore creating a violation, how do we believe that this applicant will then behave as told they are supposed to behave in the future if they have demonstrated that they are currently in a violation? So that's question number 1. And then really at the essence of it, will the removal, now assuming that the applicant is compliant with the building inspector's directive to not use the existing poles, will the removal of these existing poles be an enforceable condition that must be completed before the new tower begins operating? Thank you.
Thank you. That was my question to Attorney Stein, and I think she felt that it would be. I don't want to speak for you, but I think she felt that, yeah, the second condition followed up the first, so we could follow through on that. Susan Satori,
Yeah,
can you say?
I mean, read together, I think they're,
Sure.
Do you want me to speak or do you want the lawyer to speak?
Sure, Robin, if you want to finish, sorry, I didn't. Attorney Stein.
sure, so I'm sorry, I thought you were directing the question to me. Again, you know, the conditions were written based off what the board and the applicant discussed and to accommodate the technical requirements for moving the equipment. Again, if a condition is not complied with, then, you know, the way to ensure compliance is through zoning enforcement. I can't speak for, you know, other projects or where things are with the building commissioner, but that is the way to ensure compliance is to pursue zoning enforcement. So it may be a question more appropriately directed to the applicant, but you know, the conditions were again written as best we could to tie up that process based on the conversations between the board and the applicant.
Thank you. Susan?
Oops, I'm just trying, okay. Susan Sartori, 465 Green Street. First of all, in regard to the conditions, my understanding is that you better have a lot of teeth in there, maybe some braces too, because they don't really have to comply with that. In regard to my exaggeration over 30 stories, yes, it was a bit of a grab, but what I'm trying to point out, do we even know? Do we have any buildings in this town that are 11 stories? Let alone the fact that once that pole goes up, they can turn around and put another 20 feet on the top of that pole. There's no way of stopping them from doing that. You don't have any teeth in your toolbox to stop that. So I'm not sure I really feel comfortable about any of the conditions as they're written. And secondly, I don't understand how nobody really understands what's going on with 351. It was an application was brought forward to you just a couple of years ago. You certainly, most of you were there to be able to review it and know what was going on. In the meantime, we have still found out that they have not abided by any of the conditions. So I don't know what conditions mean in this town. I've been told that we don't have enough manpower to actually keep the ball rolling to make sure that the conditions are enforced. So I don't know how you're going to do this now with this much larger project that's got a lot of moving parts. And you're going to leave Boylston without any safety measures for a couple of weeks. Is that what I'm understanding to hear? That they won't have their safety? We've got ours, but they don't have theirs. I don't understand why. Well, I just don't understand this process. Thank you.
Thanks. They won't be left. The new one has to be built and then the Boylston will move on to it, which is why they'd want to do it that way in a two-step process.
And
But
and as far as the section 6409 eligible facility request for the additional height with an additional co-locator, my understanding is that this board has asked the applicant to accept a condition that that will not be employed. They will not extend the height of the tower. The tower will sit at 130 feet as proposed in perpetuity. And the applicant has agreed to that. And it's in the conditions.
But conditions are broken all the time, is my point in that. I don't understand. So are you going to have two poles within a mile of one another working at the same time? Isn't that not allowable in this state?
There's certainly no state law against having two cellular facilities or two wireless facilities within a mile of each other operational.
Then
There,
what is
there
it
are,
then? Because I've heard that time and time again, that this
no,
radius
there,
of 1 mile.
there are multiple locations where you have multiple towers on the same piece of property. Those are put in place because
I guess it's a
towns have,
town bylaw. I've just received information from somebody in the know that it is a town bylaw. So
it is a town bylaw. That's correct. It's
yes.
not a state law.
All right, so it's not a state law, but so we have guidelines that say, so you're going to go ahead and break that guideline and allow 2 poles to be working at the same time within a 1 mile radius. I think we need to take a harder look at all this.
My
But thank you.
belief is that that is being done merely to support the continued operation of Boylston's public safety equipment. So that there isn't a safety concern, which you raised earlier. And so that, you know, in the transition between the time that the applicant might get a building permit and they actually finish construction of the tower and could move Boylston's equipment over, that Boylston is not faced with a lack of coverage for their public safety equipment during that changeover time period. It's simply a temporary workaround. The intent is not that the intent, and in fact the conditions and the teeth in the conditions that we've been talking about is that that I would imagine that maybe certificate of occupancy could be withheld if the tower if the old tower has not yet been removed.
Do we know if we have a certificate of occupancy for 351 Ball Street?
No, as of 3 p.m., we do not.
Oh, okay. So I don't feel really very good about any of this, but thank you very much for your time. I appreciate your time and effort.
Thank you. Barbara Hopkins?
Yeah, so last not and not least, and thank you for the mic again. It sounds like we are expressing concerns about Boylston and Boylston access to emergency equipment, which means that we are effectively in a violation of the 351 project. With all that said and all the concerns expressed about Boylston and Verizon, the planning board serves the town and the public interest of Northborough, and it must determine that it's applying the Northborough bylaws and it's acting as an advocate for us, the residents of Northborough, rather than acting in an interest of what's happening in Boylston and what's happening with Verizon or the applicant. And I hope that this obligation weighs heavily on this planning board. And again, if we have an effectively project at 351 functioning currently in a violation, that really needs to be rectified first. Thank you.
Yes. Okay, thank you. Sharon?
Sharon Berube, 359 Green Street. Mr. Lawton, did you just say that they're putting that 20 feet into the 130-foot tower?
The way the condition is written is, yeah, sorry, I can let you answer.
Yeah, so the way the condition is written is that the tower is that the condition would be, if granted, that the tower is limited to 130 feet of height, period, in perpetuity.
Yeah, it's if they're permitting 110 feet and we're incorporating the 20 already to reach the 130.
So can anybody tell me that once if approved, which obviously I hope it's not, but if the tower was completed and they put in, I believe it's called the Spectrum Act, Are you telling me that they would be denied for that additional 20 feet that they have the right by law to get?
No, that would actually, it's even stronger than that. They're not allowed to apply under the Spectrum Act for a extension.
Are you
They
110% sure of that?
they're agreeing to that as a condition.
But I'm asking you, in court, would that hold up? Because everything I've read said that that is basically a given, that extra 20 feet for the Spectrum Act. And there's really no discussion about it. That's why I'm wondering if that is something, I know you're saying it's a condition, but is it something that would actually hold up if challenged?
The only way that a challenge would be brought is if the applicant violated the conditions.
Well, I see Robin Stein came on camera. I'm wondering if she has input. I'm just wondering if you have it as a condition, would that truly hold up if they then applied for the Spectrum Act 2 or 3 years from now?
The other thing, the other aspect to this that I would point out is that the Spectrum Act, all that does is it takes the ability to go through a zoning process like this away and makes it essentially a building permit. So your building inspector would still have the latitude to either grant or deny a building permit for any such extension. And with this being a condition, he can deny a building permit with that for any extension.
And would he actually have the right to deny that?
Yes, absolutely.
So you're saying 130 feet with the 5-foot lightning rod, 135 feet total, and it could never be extended beyond that?
That's the intent of the condition, yes.
That's
It
what?
could never be administratively extended beyond that. We would have to go through and give offerings to the planning board to say why we need the extra 20 feet. The likelihood is not there that we would get approved.
But I guess
Through
what
the
I'm
federal
asking,
law.
is this a lockdown solid answer, or is there potential for leeway?
There is not under the Spectrum Act at all.
There is not what?
Potential for an extension under the Spectrum Act at all. If we approve, if we get this condition on our approval.
Okay, so it's not an issue then when you read that act and it says upon completion, that basically goes by the wayside?
I don't want to
See,
speak for the town attorney, but that was written into the condition that we cannot, because we've already got our 20 feet under the Spectrum Act from this hearing.
Right. I think and Ellen, correct me if I'm wrong here, but I believe what you had just said is very important, right? And that is that what we're doing here is we're granting a 110-foot tower plus the 20 feet for the Spectrum Act already. So they cannot ask for it again because it's already been granted. Ellen, can you please?
That's what you said it.
And that's what I just want to confirm, that everybody is 110% certain that 2 years from now, we wouldn't be dealing with an application under the Spectrum Act.
No, because they've already gotten their 20 feet. They can't
That's
do it
correct.
twice.
Okay. All right, thanks. And then just one other comment. I know, Mr. Lawton, you said it's 11-story. Most houses and apartments right here online, 9 to 10 feet per floor. So a standard 3-story home, roughly 30 to 33 feet tall. So, 10 feet, 12 feet, we're still, let's just dummy it down. We're still above 10-foot stories, no matter what way you slice it. 11, 12, 13, same ballpark. Nothing that an 8-foot arborvitae is going to hide. So, anyway, thank you.
thank you. Millie, I saw your hand up. You're muted.
Okay, sorry. I needed some clarification on that Spectrum Act thing as well, because if I understand correctly, anything less than 20 feet doesn't actually need to go before a board. It's an automatic approval. Is that correct? I'm asking either Ellen or Carrie or Mike. I'm not sure.
As an eligible facilities request without any other limitation, an applicant or a tower owner can go to a building department and request a building permit to extend the height of the tower of a tower 10 feet or 20%, whichever is 20% of the tower height, whichever is greater.
That was 10%.
No, I'm sorry, I got it backwards. 20, yeah, 20,
Yeah.
20 feet or 10%, whichever is greater. And that should be that is not subject to hearing such as this. It's discretion of the building inspector.
And there
However, in this case, the condition that's been drafted and has at the request of the board and agreed to by the applicant removes that from play, as in other matters there have been other conditions applied to other towers to limit the ability to apply for an eligible facilities request to extend the height of the tower. There are several ways to do it. This is one way, but there are several other ways that a town board can do it. That's the process that many towns go through.
But if I understand correctly, even if we don't condition this, if I don't understand the point of conditioning it, if they can do it without.
Well, they can do it if you don't condition it. If you do condition it, they cannot do it.
They no, and let me see if that's guess what I'm confused of. That if we grant a tower of 110 feet, I thought with under the Spectrum Act that anything less than 10% or up to 20 feet would have to automatically be granted.
Well, it's not an automatic grant. It's just a different process.
Well, I believe if I understand correctly that you can't deny it.
No, you can deny it. There are, just as any building permit application, the building inspector can deny any building permit application if it doesn't meet with the code. And the building inspector can, in particularly with this type of application, what I've helped a number of towns with is including a section in their bylaws specifically relating to the eligible facilities requests that include things that are required to be seen by the building inspector, like a MPE study for the aggregate of multiple the next carrier on the pole. And I believe that even though it hasn't been written into the bylaws, that also exists as a condition on this draft set of conditions, that if an applicant just shows up at the building inspector without that MPE, the building inspector can rightfully and lawfully deny his building permit application.
It does. There is a condition that says that.
I want to reread that because I'm either misunderstanding what it says or what I'm being told. So I need to recheck that.
About the MPE or about the Spectrum?
Just about what can or cannot be, what has to be approved in order to, if I understand correctly, again, maybe I don't, to somewhat streamline the process of making minor or unsubstantial or less than substantial modifications. I believe that if somebody just wants to add a co-locator, they shouldn't have to go through the whole process, or adding a smaller amount, less than 10% or up to, or 20 feet or less, the point of that was to not have to go through an entire process of approval again.
Right.
Um,
We'd be able to come and swap out antennas if we have updated antennas, which is done regularly, but not anything to do with increasing the height. We could not increase the height.
Yeah.
And another sort of aspect to what I was trying to explain is the building inspector, if an applicant or if a tower owner comes and requests an extension to a tower under the eligible facilities request, the building inspector is going to want to see a structural analysis for that tower with extension and with the new with the additional applicant on it for safety reasons. If that structural analysis is not provided, or an applicant provides the failing structural analysis, the building inspector is within his legal rights to deny the building permit application, eligible facilities request or not.
Right. And again, that's for a whole structural thing versus just this element that we're, that we're trying to focus on is what is the maximum outcome, and what is the purpose of the Spectrum Act, and where does that fit into how we're trying to decide what we should or should not approve.
I guess what I heard is that they can only ask for it once, and that, so there's a condition that it's 110 feet and they're asking for it now, so then they can't ask for it again. And I don't know if that's right, if that makes sense, but that's what I heard.
Mm-hmm.
Is that true? Can they ask for it more than once, or they can only ask for it once?
We can come back if we're swapping out antennas and 5 years later we need to update them again. We can come back and do that same thing.
Yeah, but you can't add to the height of the pole.
We're giving that right up
Right.
now. So
Yep.
we would never be, not under the Spectrum Act, no.
Right, okay.
We're
That's just-
relinquishing that right tonight.
Mhm. Okay, Millie, do you have any questions further as to they're really relinquishing the right to ask to go higher?
Yeah, I guess I just find it odd that now that, they're looking at 110 feet, which would suit clearly, Verizon's needs to cover the gap.
No, we're not going for 110. We're still 130. We're just backing into incorporating the Spectrum Act by saying we're calling it 110, adding the 20 feet under the Spectrum Act, coming up with 130, so that we're in essence already exercising our rights under the Spectrum Act tonight and reaching the ultimate height that we're allowed to under the Spectrum Act.
Well, again, if I understand correctly, it's and maybe I don't. This is kind of where I find that we had a bit of a crunch for our timing to try to get some of this information to be a bit more understandable for us. But the original reason for the application at 130 or 135 feet was so you could have 3 co-locators. Is that correct? Up to, because our bylaw says that that's what you're supposed to have. As a
Right,
new
and they
tower.
would be below Verizon's antennas.
And if, but, okay,
So our building
Okay.
permit application will be for 130 feet as of, that's what
Yeah,
it will be
okay.
built at.
okay. Hmm.
So it's 110 plus 20 is 130, and then
Yeah.
any co-locators will go below.
Correct.
If Verizon's at 125, the other will be at 115. The other one's at 105.
And so if again, one of the co-locators is already designated to be Boylston? Is that
Well,
correct? Possibly. And I believe that was said they'd save space for Northborough? Or was that out of the cards deal now?
Yeah, but they could be on different parts of the tower. They could be whip antennas at the top. It's hard to know now what that equipment will be and where they would go.
Well,
But
but
we always, we managed to fit municipalities and equipment somehow on these towers.
But would they be at the same level of another co-locator, or do they count as a co-locator? So if you can have 3 co-locators, you'd have Northborough, Boylston, and one more?
Yeah, they typically don't have that kind of equipment. I mean, Mike can weigh in, but they're usually other kinds of equipment that just tack on to other parts of the tower, so they don't have to
Okay.
take up an entire array.
Okay. Maybe that's what I was trying to understand about how
Mhm.
that array would look with
Yeah,
other.
I've not seen a town take up an entire space where a co-locator would put up an array.
Right
Okay.
now, they're like whip antennas, right? They're long. It's like
Mhm.
if you look at some of the towers, they're like just a long, skinny antenna. It's
That's
similar to
correct.
what the
Yeah.
poles are up there right now.
Yeah.
Typically, public safety will install an omnidirectional whip antenna, or multiple omnidirectional whip antennas rather than sectorized panel antennas.
Right,
So they don't really count as co-locators then?
correct.
Hmm.
For purposes of taking up the spaces that we're showing on the tower, they are not considered one of those co-locators.
And as well for structural capacity, obviously a small cross-section whip antenna uses a lot less structural capacity than a steel frame with multiple antennas, multiple panel antennas on it.
Mm-hmm.
Okay, Susan, I see you have one more question, and then if there are no more other questions, we're gonna try to move forward.
Okay, so Susan Sartori, 465 Green Street. Part of this conversation is very interesting in that it looks like they're doing us a favor. I believe this all started, and originally it is asking for 2 waivers, and one of them is to go beyond our code, our town code for scenic roads, residential area A, and put up a 130-foot pole instead of a 75-foot pole. That is all we allow in these neighborhoods. So, because it's been mentioned potentially because of the Spectrum Act, they're doing us a favor. They're going to put in 110. They're going to write their things away for Spectrum, and they're going to still be putting up a 130-foot pole. Nothing has changed here. At one point during this discussion, somebody made the comment that they could eventually maybe come before a planning board to see if they could get approval to add more on, even though it is going to be a condition. So I was somewhat confused about that. But this tonight is an issue, not about the conditions to make it easier for them or make it easier to make a decision. It's about whether or not you want to comply with your bylaws in your own town to put forward what we for many years have valued as the aesthetic value of this particular area and many of the other residential areas that are designated the same way. We aren't making anything off of this. This is a business transaction for the tower people. And once you set the precedent to allow them in to do this, they'll be back again knocking on the door, doing it someplace else. And it will be a lot harder to even try to argue that or get any of the conditions that you think you're getting that are so fabulous. Because this is not part of our bylaws. We only allow 75-foot poles in residential area A. They want a waiver for that, as well as a waiver for the building. I think that you've really you've got to think more about your neighborhood and your neighbors. Thank you.
Thank you. Okay. I'm just looking to see if anyone new has their hand raised.
I'm going to ask a question if you can.
Sure.
Um, Mr. Lawton, what would you say? Do you have a input on what the gap would be pretty covered by for a Verizon tower foot wise? 115 feet? Is that covering their gap enough?
Let me try to try to restate what you're asking me. At a lower height, would the coverage provided by Verizon at a lower height be substantially sufficient or the same as what's being proposed at 130 feet? And the answer to that is in the plots that we've all looked at many times. And the answer to that is that in the as you would expect, close to the site in Northborough, the difference in the two heights is not huge. But as you proceed away from the site, to the northwest, and yes, into Boylston, there is a significant difference in the coverage that the two sites would provide, or the site would provide at 115 versus 130. And the plot that they've shown does have significant areas with white and gray coverage, or white lack of coverage and gray very weak coverage in the I guess it would be the northern Boylston area, between Route 70 and the Berlin Northborough line. And this proposal at 130 feet doesn't fill that entire area. And certainly at 115 feet, it fills less of that area.
Yeah, right. I understood that. Yeah.
Did that answer the question?
Somewhat. I was looking for a little more specific guidance, but
I don't, I mean, to be honest, I don't think it's, I'm not a board member. I don't think it's my position to determine whether the gap is substantial, because it's not my decision. I can point you to the evidence that's been presented. I can tell you where that evidence came from, and I can tell you, whether you should believe that evidence or, and how to interpret that evidence. But as a board member, I think it's your vote, not mine, is what's needed here.
are you
So, do you have more questions, Millie?
No.
Okay. Does the applicant have anything to add, or I'm just gonna ask everybody again, but I think we're gonna close the public comment part of it. I hope we heard from everybody who wanted to speak. And, it's a lot. And we've read all the letters and I really understand where you're coming from. But tonight we do have to move forward and deliberate. And when we deliberate, I've asked some questions to Attorney Stein and even on how we go forward with this. So when we deliberate, I might start with going through the WCF bylaw, which is 710040. And then we can go through the special permit site plan. We can discuss and deliberate and even review possible conditions before making any motions to vote. I'm going to leave it open, not for any more public comments, because I think we've heard. This is not to debate any longer, but I'm leaving it open in case the board members do have any questions. We could ask questions. And so And I just want to let the board members know what I've learned through this whole process, which is all new for us because we've never,
Right.
most board members here have never had a cell tower in front of them. But there's also, and the neighbors probably don't know either, is that there are local and federal standards. So we have our local bylaws. And when we go through the decision tonight, if board members, if we go through the special permit site plan conditions and the board approves it locally, then the application passes. If the board denies it locally, we need to look at the federal criteria. And the federal criteria is a whole nother set of criteria that we have to look at and consider. And if those are approved, but the local aspect is denied, then the application is still approved. But if we deny locally and federally, then it's a denial. Is that right, Attorney Stein? I just want to let the board members know.
So,
Mm,
yes, so we recommend with these applications that when you're analyzing them, you first analyze them under your local bylaw. Because if you do approve an application under your local bylaw, you don't even need to consider how the federal law would apply to your local bylaw. If the board is not inclined to approve an application under the local bylaw, then we do recommend that you also analyze the application under the federal law. And in any event, include in your decision the reasons for your decision, yes or no, with specific reference to the bylaw. You know, the reasons
Okay.
that you're granting it or not granting it under your bylaw.
So you said if it's denied locally, but you say because of federal criteria, you have to approve it, then it's approved, even if it's denied locally. But if it's denied locally and federally, then it's a denial. That's what I just want the board to
Yes, so
understand that.
again, our recommendation for how, yeah, no, absolutely. So our recommendation for how we think boards should approach looking at these is to first evaluate the application by just applying your local bylaw to the application and deciding if you would grant the special permit and the site plan and the waivers. And ultimately, if the board says, yes, we would grant this under our bylaw, you don't need to reach the question of would you be required to grant it under federal law. If the board looks at it and says, this is not something that just applying our bylaw we would grant, then my recommendation is that you still apply the TCA and ultimately, you know, I mean, this is kind of general way of saying it, but you know, in my opinion, if ultimately the board's decision is the reason that a wireless communication service cannot be provided and needs to be provided, it's likely a federal court is going to find that's an effective prohibition.
Mm-hmm.
Can you repeat that? Robin, can you repeat that?
Sorry?
Can you
Sure.
repeat
So, you know, if you get to the federal law question, so if you get to the question of the federal law,
that? Mm-hmm.
then, you know, my general opinion is if the applicant has proven that they, you know, have a significant need to provide the service or enhance services, and your decision is going to be the reason they can't provide them, meaning there's nowhere else to do it. The only thing that's stopping them from providing the services is a denial, then that's a very difficult denial to defend under the federal law. And it's likely a court will find that it is your decision that is effectively prohibiting services that need to be provided if the applicant has met those standards. But again, that's only if you get to the question of the federal law. Still recommend that you evaluate the application under your bylaw to start, and you make specific findings and a decision applying your local bylaw, and that you only need to reach federal law if it's not going to be approved under your local bylaw.
Okay.
Okay. Does everyone kind of understand that? To the best of our knowledge. Okay.
Yeah.
So if you have your books, I was going to start on page 130, which is the wireless communications facilities.
Which book are you in? What year?
I I'm in 2022, but it's 710-040. It hasn't changed, so,
Okay. Got it.
okay. So 710-040 is a wireless communications facility by law. Talks about the purpose and intent of the wireless communications, which I did read, is to protect the maximum extent practical the rural character and aesthetic qualities of the town of Northborough, the property values of the community, and the safety of the citizens. And before go any further, actually, I want to ask Mike Lawton, in your opinion, I want to ask you about the safety of the citizens because I don't think we've talked about it. I know that we talked about the tower will collapse upon itself at 57 feet. But then there were also, was it the EMEs?
Yeah, EME. The applicant has provided a EME MPE study on the proposed Verizon installation with all the antennas and bands that they're proposing to place on the tower. And I've reviewed it, and the site as proposed with Verizon on it, it complies with 47, I forget the actual code, but it complies with the OET standards for maximum permissible exposure to the public. So that analysis is demonstrative of compliance with the FCC's standard for exposure at the ground level or at 6 feet above ground level around the tower on the property and adjacent property.
Okay. And I asked you once because I didn't think I could ask it. I didn't think I was allowed to talk about health things, but I can ask the question. And you had mentioned to me, and I just wanted to make it clear that you had mentioned that it was way below the standards.
Yes.
So it's very far below the standards. It's not like it's even close.
Yes, it's significantly below, and of course, you know, what we're talking about here is a potential tower with one applicant or one radio service on it. Potentially, additional ones would come, whether they are public safety from Boylston or potentially Northborough, and also the other two commercial carriers, T-Mobile and AT&T. And when any of those additional carriers come along, that MPE study needs to be refreshed and revised to include the aggregate effect of A plus B and then A plus B plus C in order to prove continued compliance as potential future co-locators come on to the would seek to come onto the facility.
Mm-hmm. I just wanted to get your review that you feel that it is safe and that they prove that they're below the standards required.
Yes, they've proved that they meet the FCC standards, the OET standards for RF safety.
Okay, I just want to make sure all board members and the residents also knew, because I couldn't remember if I asked you, you know, offline or online. Okay, so when you get to the 710-040 wireless communications, there's the purpose, intent, applicability, definitions, and then application process, which they followed, unless anyone feels that there was something missing. Then we get to E, which is the general requirements. And so I thought maybe we'd start by going through those first. No WCF shall be placed except for in compliance with this zoning bylaw. All WCFs shall be collated to the maximum extent practical and technologically feasible. So there was, unless somebody feels otherwise, I saw in the exhibits that they looked at the other antennas within a mile or two.
Mhm.
And due to the I think they're on all the other four in Northborough. And that this area up in the northwest region, there's no antennas up there. And the topography is higher than the ones down lower. So I don't know if anyone feels that they didn't co-locate, they should co-locate, but according to the exhibits that we got, they said they looked into co-locating and there were none close by. Okay. So the next section talks about construction. There was a construction document that was given to us. It talks about co-location of 3 other wireless communication providers, which they said they will do. I'm just scanning through it. Descending order of zoning preference, and I I've read this carefully too. Industrial, business west, business east. And I agree, it says industrial first and residential last. And I hear what the neighbors are saying. But after learning a lot, sorry, about the federal regulations, that if they show that it's needed and the industrial areas aren't close by, then they go down the order. Industrial, business, business east, business south. The closest one on the industrial district is over by the senior center, but there are no industrial areas close to this location. So on the next page, and anyone interrupt me, I'm just going down the list of what's in our bylaws. So if anybody wants to add anything, please jump in. The next one was 6. No WCF shall contain more than one monopole tower or other structure. No more than one, except for co-locators, shall be constructed on one lot. No WCF shall be located closer than 1 mile to any other WCF. And this was talked about with the conditions and last time, that by taking down the one at 351 Ball Street and moving on to the other one, that's a self-cure because you're getting rid of the other one. And I feel that this one is further away from the road than 351, even though it's still in the middle of the field and you can still see it. I think moving it back further on the site is better than adding on to the pole at 351 Ball Street and making that one taller to get to the 130 feet right there in the front yard. I'm not sure if anybody else has any input about, or if this is the way you want to do it. You could just deliberate and we could talk about,
Yeah,
instead of me going one by one.
I think it's good. I mean, I don't think we could add on to the one on 351. Wouldn't be structurally feasible, I don't think.
Right. But what they did on like Main Street at the police station is they took down the old one and put up a new one and made it higher. But this wasn't even an option there. So
Yeah,
I'm just trying to go down all of them. Maybe I shouldn't even speak to all of them.
yeah.
But the next one has to do with the height. 125 feet in industrial, 75 feet in residential. And I hear what the neighbors are saying. 75 feet, stick to your bylaws. And I wish we could. Like on the local level, as a planning board member, I would definitely deny the waiver. I would deny it because I would stick to the bylaws and stick to just looking at Northborough. But then if I went to the next level, so like we said that if you deny it locally, you have to look for the federal criteria. And the federal criteria is there probably because every town would deny it. But, I've had a hard time grappling with this,
Mm,
but for the federal criteria, if they prove in our eyes with the plots and the numbers that there's a significant gap and they need higher than 75 feet, and then it's difficult. In my eyes, I don't know. It's up to you. It's up to the board members to say what they think. But
mhm.
in my opinion, I would deny it at the 75 feet locally because I think that under our local bylaws, I would stick with what we call for. This is a rural scenic road. The monopole's in the field. It's almost double the height. But if I have to look at it federally and if they proved that they need the higher height, then I have to feel that yes, that they showed it on the plots. Because when you look at the plots, I could see the substantial gap with the white. And originally I thought we just had to look at Northborough. But then after asking questions to town council, we still have to look across. We can't just stop at town line, unfortunately, as much as I would like to. But I don't think federally we can do that. So that's where I am. I want to hear from everybody else because this is one of the waivers.
So to be honest, I think, I look back to a couple of years ago when we voted on the dog park, right? We knew it was close enough to Marlboro that Marlboro people were going to use the dog park, right? We still voted for it. Why? Because it was in the best interest of everybody, not just Northborough. We're a community. We're the state of Massachusetts. Think of that as a community, right? Um, and so just like we wouldn't want Boylston to not put in a poll because, you know, it doesn't work out for them, it works out for Northborough. Well, we would be upset at that, right? Just like they would be upset at us not putting a poll in that helps them. We got to help each other. And the unfortunately the not in my backyard thought needs to leave. It really does. That's my opinion.
I do think, thank you, Bill. I mean, I do think that the, and maybe I got hung up on the term significant because, so, well, maybe we only have to put a pole up high enough to make it a not significant gap. So after talking with, the consultant and attorneys, basically saying that the federal court is seemingly more lenient to just needing any type of gap. And so, a 75-foot pole in this area would probably not make a big difference. So I honestly feel that maybe in this arena, a 75-foot pole is somewhat might be called an effective prohibition. So for this type of communication. So I do believe we need to go higher than 75 feet. I'm not convinced of what the height would be yet. Yeah.
So I would,
I do think sorry, I did want to chime in a little bit on the scenic road aspect of this, which I think is a very big consideration on my part, and maybe I'm sure others. That is a huge tourist industry in our town. And people come from all over New England to drive through that area, to go to Tugus, go up to that area. They enjoy it. I do think that's a big piece of what I'm concerned about, whether or not the height of the 135 pole really does fit in that with that. I'm not sure. I don't feel it does. I think it's a rather bold contrast for what that area is. Um, we have a scenic road designation for a reason. And this isn't in alignment with it. It really is not necessarily a it isn't a it's a scenic road designation somewhat protects what we have for views and for our features. And I don't think this is I'm not sure a high pole is in line with that, but I'm just talking.
Well, we
I
don't
would
have to
just-
decide on height right now, yeah.
I was just gonna say, so I agree with everything Amy said as well. And from a local level, I don't think it's meets up to our bylaw standards. But I do think they've demonstrated a gap in coverage pretty effectively. And then based on everything we've heard from our attorneys and from Mr. Lawton, they've demonstrated that as well.
Mm.
I do believe that the 1996 Communication Act is going to trump any local laws, and I really don't have any confidence that we would win. And I don't think Northborough has a big appetite for lengthy lawsuits as well, especially considering the budgets in town. So yeah, I kind of just right in line with what Amy said. From our bylaws perspective, never. But I don't think we have much of a choice from the Federal Communications Act.
Hmm. And I just want to speak to Bill a little. I know you have your opinion and I have mine, but I think Boylston did say no, which is why they're here. So I don't agree with, I mean, I don't fully agree with the help thy neighbor because I don't think thy neighbor helped us. I think if they went into the town and the town administrator or the building inspector said, yeah, we'll put it on our municipal property, then they would have helped us, but they actually said no. So that's why it ended up over here, even though I think there was a big gap over there. So
I don't think they said no. I think the communication, if I understand, again, I've been wrong quite a few times seemingly, is that they said it would be difficult in this town because we can only have one pole per lot on the municipal property. I'm not aware that they looked at residential or any
Yep.
other areas. So again, that in my mind falls back to, I don't know what the communication was.
mhm. Good point. But- So it sounds like though, the majority of us feel that, well, I don't know if we go to that point yet. Maybe I'll just continue with this before we talk about the waiver in full, but it sounds like 75 feet wouldn't do what they needed to do. So there would be some sort of waiver needed, is what I'm hearing. Let's see. Just want to make sure I don't forget anything here. Number 8, it talks about the setbacks. So now we're on to the second waiver with the setbacks. In my opinion, I would be a hard no on the setback too waiver, but since it's the actual owner of the property, like the waiver isn't getting the tower close to a neighbor who doesn't already own the property. I see to the west, and he's surrounded by a lot of APR land, which is a good buffer. And the only waiver setback is towards his own house. I'm not saying that I don't want it to set precedent that I would okay a waiver in the future, but I felt like I was okay with this waiver because he's making the choice on his own property. And he's saying, okay, I'm okay with it close to my house. I'm
Yeah,
not sure what others feel.
I agree with that.
To be clear, it's the setback from the property boundary and the house, just to be clear.
It's a property boundary and the house, right? There's two.
Yeah, just to be
Yeah.
real specific.
Yep. But if it wasn't his own property and if it wasn't his own house, I would be a hard no, but I feel like
And the
since
abutter
he,
didn't want it, right?
yeah, and the
I mean, if
abutter
the
didn't
abutter
want it.
agreed, then okay, it's maybe not a hard no, at least for me anyways, right? If the abutter agreed, okay, you can have your setback, I'll agree to it. But I agree, if the abutter was somebody else and they said, no, I don't want that, then, it would be a bigger discussion, I think.
Mm, Yep.
I would feel it'd be more of a safety issue too, but he's willing to
Right.
take the chance. Buyer beware.
mhm.
So is everybody, I think this was somewhat, at least for me, an easier one. Is everybody okay with the waiver to the setback and
Yep.
to
Yeah.
the residential?
I am.
I am.
Yep.
Yeah, so that's one thing we agreed on. Like I said, because it's his own property.
Yeah.
All right. Um, the next one's residential. The next one has to do with the school, which don't apply. All structures shall be removed within 1 year. There's a condition, should this be approved, that if it does cease to operate, it would be removed within 1 year. Our next bylaw says there's a RFR measurement, and they agreed to that. And then the next one has to do with the noise measurement. Should it be approved, I actually added something to the noise condition. I saw that some other towns had conditions where if there's going to be a generator backup, that it has to be run during the daylight hours because it's the backup generators that make noise. So I've noticed that other towns either have that the backup generators have to run their tests during, between 9 and 5 or not after 6 o'clock. I don't, if that's something that
That's
would be,
fine. I don't see that as a problem.
yeah. Number 14 talks about the bond for removal should it cease to operate. And that was an agreement with the applicant too.
Did we had a price on that bond, right? 40,000 or something?
I think they did come, that was in one of the
Draft condition.
draft, one
Yeah.
of the submissions. I
Yeah.
don't know if that's something that has to be agreed upon in the future or if the 40,000 is something the town accepts. Usually, they come back to us with bond amounts. And Lori, I don't know how the bond amounts work. Shall we go that way? Is the $40,000 acceptable or is that something that's worked out after?
I don't know where the 40,000 came from. It's not in the condition that I wrote.
No, but it was a
Oh.
submission.
It's somewhere.
It was one of the submissions that came
Yeah.
earlier on in the application process.
Yeah. I definitely saw it and I didn't think it was actually for
But what I'm used to is that our consulting engineer, so of course that's Mike Lawton, would prepare a cost estimate and propose that plus a contingency amount. So that would be provided to the planning board and it would be provided to the applicant for approval. And then the applicant would supply that amount. If they had an issue with that amount, then they could contest it and the planning board would decide whether another amount was acceptable. So that's the process that I'm used to. So the $40,000, I don't know who came up with $40,000.
I think that was what we submitted. It was an estimate. It was a quote that we
Okay.
had gotten.
Yeah. I knew somebody had written. I didn't make that one up.
No, you're right.
But I
Um,
guess my question is that, I mean, and maybe this goes to Lori and Mike later to work out, but that certainly does not seem like enough to, for the removal of to cover the removal if, when needed, of a tower. Because this,
My opinion based on seeing these in this type of removal bond and estimates to justify the cost of removal bonds is that 40,000 is sufficient for this type of tower in this location.
so that's not just for the Verizon antenna array, that is for the whole tower.
Correct.
About
That would be to
$40,000,
that would
130.
be that would be to take down the I'm certain that the foundation would stay, but they would um, disconnect the ring bolts at the bottom of the tower and drop the steel on the ground and take it away for 40,000. It's really it's really no more than the cost to rent a crane. You know, because the crane and you're bringing a crane to pick it up and lay it down. And disconnecting the bolts at the bottom is less of an issue.
Okay.
okay. So I think it sounds like the way the condition was written, though, there'll be an estimate, they'll use your estimate and the town will get an estimate and there'll be an agreement.
And if that were to happen in 20 years, I'm assuming the bond amount would be adjusted accordingly for cost inflation.
Sometimes towns do put that in their request for the bond amount or potentially you know, some sort of 10-year review or something like that of the bond amount. But I'm not sure how long the building permit cycle is in Northborough. Could also be at the same time that the building permit needs to be renewed.
Okay.
You know, but that's up to the board and the town as to when that amount is, you know, right sized, given current costs.
Okay.
Okay. All right. The next one talks about planning board contact for emergencies. That was a condition. A qualified independent structural engineer shall perform a safety inspection. That was a condition. So that hits all of the general requirements.
Mm-hmm.
The next part is design provisions. The first design provision is that it shouldn't be the lattice type construction, which they did not submit. Then it goes into signage, which we have a condition and already discussed that. The third one says all monopoles, antenna support structures shall be of neutral colors that are harmonious and blend with the natural features of the environment and shall be constructed out of non-reflective materials. I definitely wanted that in a condition that it's non-reflective materials. I don't know if that's in there, Lori, but I know it came up before that the applicant discussed a color and that's a very hard decision, I find, as a board. Like, does a color matter? Do you want a color? I know that, you know, if I was a neighbor, I don't know.
Hmm.
I don't know what I'd think about color because I've read in some places that the silver color matches the sky more. Some people like to do brown because it's neutral, but then I don't know. I don't know.
Is transparent a color?
Right, invisible cloak.
Yeah.
The number 10 of the findings of facts. So they had proposed a galvanized steel finish. So I put that in the findings, but it's red because I know the color of the structure has been a subject of conversation. So
Right.
whatever they said that they'll make it whatever color you want it to be. I know brown was discussed at the last hearing. So you folks tell me what color you want it to be, and I'd be happy to write that in there.
Definitely non-reflective if it stays the regular color. I don't know what board members think, but I've asked my family members or other people not what would you think? I don't know. That's a really tough one because as a resident, I wouldn't want it there at all. So like Millie said, invisible. So it's hard to pick a color.
Mm.
And I talked about possibly a tree, and there are different opinions on whether a tree looks, a monopine. Does it look worse, better? And and I know the applicant said they didn't want to do a monopine. But there is one monopine in town, and there are a couple that aren't monopines. So,
I don't know. I honestly think that a monopine might almost attract more attention at that height and not big disparity.
Yeah.
I feel like it's just such a, big difference in what's around it, height wise, that a neutral color definitely in my mind, but whatever that means, I'm not sure.
Yeah, I mean, for me, it's either a brown or a green,
Mm.
right?
Yeah, for me, it would have been brown.
where it's above the tree lines and at the sky, though, is the brown going to show up more than?
Good point.
You're never
I'm
going to get that
actually,
perfect. I mean, there could be clouds and then you need
yeah.
white, right? I mean, we could pick every color.
I'm gonna
It's
go
not going to
brown at
be,
the bottom and light blue, sunny day
yeah.
from, 70 feet up.
I mean, it's the lesser of all evils, right?
And I think they said that brown was the typical color that they would be painted for most cities or towns.
Yep.
Mm.
Actually, I would say that most monopoles that go in these days go in with the bare galvanized finish,
Yeah.
which is not reflective, but it is, it's essentially sort of grayish silver. Beyond that, I mean, I don't have any other input. I don't even get to pick the color of my living room paint. So
I don't know if I've ever seen a brown one, but I do notice that telephone poles somewhat blend. If they were metal, would they blend as much? I
Mhm.
don't know, but as he said, I agree that the ones that I do see are mainly silver.
I think as far back as where that element of it would be, that I don't know that the color down at the base is that significant because you have other, buildings and things somewhat nearby, but I think for me, it's more what you see above the tree line.
Mm.
And I would rather see that be less. And galvanized steel or something not, yeah. I would have a harder time with a brown sticking up, 70, 130 feet.
I'd say we could circle back to it, but I don't think we'll come to any more decisions. So, I mean, we can pick a color and then
What color was the crane in the photographs? Just curious.
I don't know.
I think it was like a
Yeah.
beige.
I think it was like a beige or something. That was pretty noticeable.
I have it down.
That's fine. I mean,
I know, I'm just wondering,
yeah,
because we do have a picture of what it looks like silver,
but
and then we
maybe they
do have
want
a
it to
look
be, yeah,
black.
yeah,
And the silver actually might stand out less,
yeah.
in my opinion, when I look at these,
The photo
um,
simulations.
the photo simulations.
Yeah,
Yeah. Okay.
Yeah, I think I'd hate to like pick a color and then say, oh, when it's up, it looks horrible. Whereas just going to build it like every other tower.
yeah.
Yeah, if I could show you the simulation, the the white stands out more at the bottom of the crane because it's up against the trees.
Right.
And then the black stands out against the sky and the silver, which is gonna stand out, but I think it stands out less.
Okay.
Okay.
So we're just gonna leave it, but
Galvanize.
non-reflective.
Yeah.
Don't want anything shiny.
No. Okay.
Okay. Um,
And just a quick question, and maybe Mike, you can answer this. Do the co-locators have color elements to them? Generally?
On the platforms, I mean, typically the platforms would be made similarly out of galvanized steel, the pipes. And then the antennas that would be mounted on them are
Yeah.
typically sort of whitish, sort of almost slightly off-white.
Okay.
And the radio heads often have metal cooling fins on them, so they're, again, a base sort of a flat silver. So it's nothing should be reflective up there.
Okay.
On
Curious
the,
about.
the standard equipment that goes up is not reflective, but
Yeah.
but and you can instruct that they paint the antennas, but that becomes not only a nuisance, but a maintenance concern,
Sure.
because as soon as they paint them, at some point, 5 or 10 years, that paint's going to start flaking, and who's going to fix it?
Yeah. Yeah. Okay. Thanks.
one thing that I was gonna ask when I was talking about the bond, and I think I forgot to ask, but maybe I did, is I know there are a lot of antennas out there right now that have old equipment on it, like there were other providers. Can there be a condition that if, say, AT&T goes out of business, that they have to take off the antennas? Like a lot of antennas up there have the old equipment still up there, even though they're not operational anymore.
Hmm.
That's an interesting question. I mean, if you look at the perfect example of that, I think we talked about, Amy, is the tower just off 495 at New England Sports Center, just at 495 and 290, or near 495 and 290. I think there's 7 platforms, and there's only 3 wireless carriers operational right now. So the rest of those equipment platforms are inoperable at the current time. Some of them, the carriers continue to pay rent, even though they're not using them, because they might want them for future, or they don't want someone else to go there. But if there is in fact obsolete or unused equipment on the tower, there's actually one carrier who I used to be employed by who has unused equipment on many towers here in Massachusetts, and doesn't seem to be coming off anytime soon. So it would be difficult to enforce such a condition.
Is it so nobody would ever come and take the equipment away?
Unfortunately, there's a cost to remove the equipment from the tower. And once a company has gone into Chapter 11, that's not their priority. So usually what will happen is if somebody else comes along and wants that space on the tower, they will remove the unused equipment themselves.
Okay.
So nothing comes down until the tower comes down.
I mean, they still are being taxed on the equipment, so I'm surprised that they would continue to pay the tax. So, because they are assessed, these pieces of equipment are all
Well,
assessed.
they may be getting, I don't know how much of the news you've been following, but they may be getting billed for the tax. They may not be paying.
Yeah, but
What happens
we're
if they
allowed to
stop
do that?
paying?
We
Well,
can do
could there
that?
be part of the bond to take it off? Like if they stop paying and no one's paying, is there any way to get them?
I don't know that that's ever been condition in any, certainly the removal of the tower, if there's no use on it anymore, no actual continuing use, but removal of the individual platforms if nobody is using them. I haven't encountered that anywhere else. So I mean, I suppose you could put it in as a condition, but I'm not sure your building inspector is going to be capable of determining what's in use and what's not, in order to find that certain equipment needs to come down. I'm not sure there's really any way of knowing other than what I just said about the tower by New England Sports Center. Obviously, there's 7 arrays on it, and there's only 3 carriers, so something must be not operational right now.
But this one only holds 3, so you can't put 7 on this.
That's correct.
No, but I think to Michael's point, if it were to go down to 2, right? Who's
Yeah.
the third one? Which one isn't working, right? Which one isn't functional? Those type of questions, the building inspector is not going to be able to know.
And to ask him to chase around after that, I think he's probably got a lot of other things that he should be working on.
Lori,
Sorry, he or
did you
she.
have your hand up?
Yeah, I just wanted to remind you folks that every time a new applicant goes on, that they have to go through site plan approval with the planning board for a co-location. So as part of the co-location process, you're going to get the specific information about where that vendor is going to be located on the pole. And there is also an opportunity at that point to put in conditions of approval
That they
for
take
that
off the other one?
specific co-location.
Okay. So back, unless anyone has anything else to add, I'm going to get back to 710-040.
Yep.
The number 4 talks about building mounted, which this isn't. Number 5 talks about the unmanned equipment shall not contain more than 200 square feet of gross floor area or be more than 10 feet in height. Is that part of the conditions, Lori? We just want to make sure. I think the site plan should prove that they're not.
Yeah, so I put it in the findings of fact, the size of the lease area. So that is findings of fact number 4. So it specifies that it's within a 70-foot by 70-foot fence compound, which will be enclosed by an 8-foot tall board-on-board fence within a 100-foot by 100-foot leased area.
I'm just thinking the 70 by 70, that's bigger than 200 square feet. So does it meet this requirement? I don't have a calculator. Oh, per carrier. So it'd be 2, 4, 6, 8, 10 if there's 2 towns that need equipment. Well, while we go forward, Lori, can you check to make sure that we meet that number 5?
Yep.
Okay. Number 6, there shall be a minimum of 1 parking space. That's there. Number 7, every WCF shall be protected against unauthorized climbing. We don't want barbed wire because it's a scenic character. So there's no barbed wire or raised wire. The fencing is going to be a wood fencing, which I think would look best in that area. I know Kearney Park is a chain link, so I think wood is more aesthetic. Does any board member have any input, concerns?
Nope.
No.
Now, Lori, we also have the condition that, trees and plantings need to be, replaced should they become diseased or died. who comes and maintains the fence? Like, say a fence is broken, or should there be part of the clause also that any part of this, the fencing, if it becomes rotten, damaged, falling apart, needs to be replaced within 90 days or something? I did notice there are some towns that have maintenance conditions. Is there any
So
way?
TowerCo, as the owner of the pole, would
Mhm.
be responsible for maintenance. I think it's a given that they would maintain the fence, but if you want to add that as a condition, I'd be happy to put it in.
Yeah, I'd like to add it because I would like just, I don't know how many days is reasonable, but if the fence in the compound is rotting and broken and falling apart, it should be maintained and replaced.
Does that go through before design review or anything? Because personally, I think a wood fence would be more likely to start rotting than the wood composite or substitutes that we have.
The wood tends to be more hardy than vinyl fencing.
Okay. Okay.
And then of course the other option is chain link, which
Oh, no.
of course is you can see through.
Yeah.
Some woods are hardier than others, like cedar, doesn't that stronger than pine? Can it be a cedar fence so it doesn't rot as fast?
Or pressure treated.
I don't know. Do they make fences out of pressure treating? I did look up different fence types and they mentioned fines, they mentioned pine or cedar, and that cedar lasted longer. So maybe that would be better than they wouldn't have to maintain it as often either if it was made out of cedar. Is the applicant okay with that?
I'm just gonna ask Carrie. I think I lost her.
We can come back to it.
Okay.
No, you didn't lose me.
Yeah, there you go. Okay.
If you make it a condition,
They
we
can
will abide by the
add that.
condition.
Okay.
Okay. What does the board feel about that?
That's fine with me.
Same.
Yep.
Okay. So the boards will be cedar, so they'll last longer. And they'll be replaced if rotten or broken. Should he use the same within 90 days like the others,
I
or
was gonna say a
within?
time period. Within a time period of, complaint or issue being notified.
Seems like with our other conditions, then within 90 days of, being made
That
aware
should
of
be
it.
fine. I mean, weather permitting,
Right, weather permitting, but. Okay. Lori, did you get all that?
I did.
Okay. Then it talks about the FAA and the lighting. We did get a report that it's not tall enough to need FAA and lighting. One other condition I added was during the application, it was discussed that it would be a crank light, so it'll automatically go off. I just want to make sure that's in the condition somewhere, that it's a crank light, so someone doesn't go out there and leave it on, and now we're lighting up the area.
What does, when we're talking about something like that, what does the actual construction element look like? Is that something that is under the purview of the building inspector, the time frame? How much disturbance to neighbors, any of that stuff? Is that?
Well,
typically
we
they're
have,
motion sensors, so they just go on when somebody's nearby.
No, I guess what I'm asking is the actual construction process of a tower.
Yeah.
What does that look like for neighbors and residents and, interfering with their lives for 6 months, 2 months?
And
Okay,
How
I
long?
understand it's a pretty quick process.
okay.
Yeah,
In our bylaws, we state the hours that construction can occur.
Mm-hmm.
Amy, in answer to your question about the crank light,
Mhm.
if it's in the design plans that it's gonna be a crank light, then it'll be a crank light.
I don't know if it is, or if it was just something that was stated in one of the papers that I read. There's so many papers, but I read, and I remember somebody asked the question that they didn't want the light to stay on. I think one of the neighbors.
Yeah.
right,
And
that's why, yeah, that's why I said it's usually a motion sensor and then it goes off after it goes on and then it goes
right,
off if somebody's in the area or a technician is coming in, would have to need a light temporarily, but there's no lighting per se.
Okay.
they talked about a crank light too, because I just don't know if would a motion sensor go off, like there's probably animals out there, like I know where I
Yeah.
am, there's deer and
Yeah, I mean, again, we can put it on the plans and see what, so it's identified what it is. If you have specifics regarding that, tell us.
well, I mean, I wouldn't want something that's lighting up at night, so the neighbors are disturbed.
That's
So
fine.
I've never heard of a crank light, but
I
this
don't know what
person
it is
said
either.
the person who presented said it was a crank light, so you turn it on and then it automatically goes off.
So it must be like a timer kind of thing. Like you just
Yeah.
time it for a couple minutes and then it goes off and then you have to turn it back on to go on again.
Yeah.
Imagine.
I mean, I'd rather,
I would be concerned about having a type of lighting that isn't motion activated. Because what if you had kids, deciding to
Mhm.
scale the fencing? And they don't know where the light is, but a motion sensor light would pick up the kids climbing the fence.
Hmm,
I
I don't
don't
know.
know what the crank light is, whether, are you suggesting that the only ones who could turn on the light would be those who know where the crank light is?
That's what it's supposed to be. There should be no kids there. Like, I think they go inside I mean, there's all sorts of signs not to go inside the area. I
Yeah,
would
but the
think it's,
point, the point of the motion sensor lighting is so that if there's any unauthorized access, the light will go on. But
mm,
if it's a crank light, that wouldn't happen.
I think the light was used if there was a technician out there and needed to be out there. Like, there shouldn't be kids on the property running around by the cell tower.
Well, of course, there shouldn't be, but that doesn't mean that there wouldn't be. I mean,
Right. But I don't know if that would really alert someone. That'd be like putting a motion sensor near my pool. And if a kid falls in, the light's going to go on, but I'm not going to see it. I think I'm more concerned with it being a motion sensor and there being deer and animals out there and it's setting off the light all night. Because that was a concern that the neighbors don't see the lights going,
So the lights are generally, if I may speak,
Sure.
we generally standardize them as motion sensor lights, and the lights and the detail will be in the building permit plans, but the lights are generally pointed toward the ground so that they're not pointing out at the neighbors. They're generally just pointed at the equipment for maintenance people to go in. That's my understanding of it.
So
Helen?
they're inside of the fencing, so it would be on the fencing pointing down. It won't be pointing out.
That's
Right,
the lighting detail we often provide, yes, that they'll be
you can see
pointing
that.
down and not out.
I've
They're
never heard
pointing
of,
at the, go ahead.
I would just say I've never had lighting be an issue for anyone and we go back into towns many times for different new towers at different locations. No one's ever complained about that situation.
Can we just have a condition that the lighting will be pointed down inside the compound? I mean, since it's not a problem, it shouldn't be a big deal.
That should be fine.
Okay. then there was the next one, number 9, talks about 8 view lines. That's something that we were given. That's not something part of the design.
Yeah.
Then it talks about landscape plans submitted with the application. Right now, the landscape plans are still open-ended because we had talked about street trees. And
Mhm.
I can even share my screen, but in Lori's condition, she wrote every 80 feet. And I talked to a local landscaper, and I could share what he shared with me, but he went along with what Lori thought should be for street trees, which were maples and red oaks or red maples, but he said every 40 feet, not every 80 feet. And he even thought there should be some Norway spruces in between, set back so it's not a straight line like red maple, red oak, Norway spruces, just to break it up along the street. But we have a condition that the landscaping will be discussed after the approval. But, I would like to have something in there now that at least change it from 80 to 40, because I feel like 80 feet is super far away and that really wouldn't buffer.
For what length of this, what are you talking about? For how long? And what's the distance?
Let me pull it up. Lori had and we had talked about it the last time along the
Are you talking just along Green Street? I mean, on Ball Street? Or are you talking around the fence?
this
Or are
this
you
is the
talking
street trees.
the street trees?
Yeah,
Okay.
so like we were told we couldn't do the silo or the monopine, but we could do the street trees. So the conditions that went out, and there was one change made, but not to this one. It says prior to issuance, this is number 2, prior to issuance of a building permit, the applicant shall submit for planning review and approval a landscape plan depicting installation of street trees along, say it's getting cut off. Street trees
Yeah, I have
along
it along the property frontage of 321. Yeah, that's fine. We do want to do it this way. We want to be able to submit a plan for you to approve.
Yep.
So-
But I wanted to change the average spacing to 40 feet versus 80 feet because that's too far spread apart.
Okay.
Along the property frontage of what? You said 321?
321 Ball Street, 351 Ball Street, and 409 Green Street. So it's all the street trees.
Just in front of their, around that corner.
Yep.
So where they already, okay, so where the gaps are, effectively the visible areas of that area, that corner.
So
Can
the
you
street
show
trees
on that?
on Ball Street, like right now on Ball Street, I think there were trees there, but they were taken down.
Can we leave that question open for the
Yeah.
plan? Because since we have to come back and get approval, because we have to really look at that
Yeah.
and see. So if we can just leave the landscaping condition the way it is, and we'll come back, and if, you can have that discussion then, because you won't approve the plan if you're not happy with it.
But
Yeah.
then there'll be no trees if we don't approve it. I think if we approve the tower and it says 80 feet, then it will come back to us and say, well, you guys
No, don't
agreed
put
to.
it, just don't put any distance in there, and just say it's going to be subject to the board's approval when we come back, because we have to come back before the issuance of a building permit.
But what if the board doesn't approve it, then it's too late?
The board doesn't approve. I'm sorry.
Like, I feel like if say the tower got approved tonight, but the landscaping plan wasn't approved, then
But the condition says that we can't get a building permit unless we submit a landscaping plan to you in advance of getting a building permit that you have to approve.
okay. But I do want to give the applicant, something to at least go by.
Well, we
when they
hear
do.
you. We understand that your concern, and 40, 80, at least we can look at it, have time to consider it, and come back with a plan. And if you're not happy with it, then we don't get a building permit until you accept it. So it'll
Mhm.
be something we'll have to discuss.
Well, I just want to
But we're not
Stated.
landscapers, so we're
Yeah.
not really
Right.
comfortable to
Yeah.
provide that information, but but we're okay with the condition. That was fine. We looked at it, we said that was fine. So, but I would just take out, if you're not comfortable with the 80, just take out the spacing requirement, spacing to be approved by the board. Just put that in.
Mhm.
I don't know. Attorney
Yeah.
Stein, what do you think of that? Like, I feel like there has to be some sort of minimum. Or is it,
Well, you're
is it,
gonna have full, opportunity to, have a discretion on what you approve. If you just
Mhm.
take it out, then you can tell us, no, that's not, whatever we propose, you can say that's not acceptable.
Because you wouldn't get a building permit until we do, correct?
That's correct.
Yeah. The only thing, Amy, I would want to add on to that is that at some point a time frame upon which the landscape plan needs to be complete
Mm,
effectively, eventually. But I mean,
Well, it's before we issuance of a building permit, so we can't get a building permit until you
no, I
approve it.
actually meant the landscape,
Oh,
the actual
Installed.
installation of the plan.
yeah. Yeah, again, that's weather permitting, like depending
Sure.
on the tower's
Yeah.
built.
But start with
Yeah.
a time frame because we've certainly seen some that never actually
right.
start.
So it could be like within 6 months, weather permitting,
I'd say a
like
year.
6.
I mean, well, maybe 6 months because would be in my mind, it's not well, it's a pretty, yeah, I'd say a year. Weather permitting, because that's probably 6 months worth of landscape work. I mean, not,
Yeah, I mean, if we finish in the spring, I don't know, or say the
Yeah.
summer, I don't think you can plant till the fall. I don't know.
Yeah.
Again, I don't know.
yeah.
We can
I mean,
propose
that's-
that as part of our plan and, timing to be approved of by the board too.
Yeah, I think
Um,
that's critical. Yes.
So typically, so the building inspector issues a certificate of completion for cell towers. He doesn't issue an occupancy permit. So all the work would have to be completed prior to issuance of a certificate of completion.
Oh.
So that's the timeline. So if they're looking for a certificate of completion, say within 3 months, and the trees will have to be planted within that window. Because once the certificate of completion is issued, then we don't really have as much pull. So the building inspector won't really have the power to, won't have anything to hang over their head to get them to do it.
Okay. I think we're gonna have to talk through that condition though, just to make sure, how do we want to leave it?
Okay.
Prior to issue a building permit, or we can talk about it after, or we can talk about it now, because we'll forget to go back, but prior to issuance of a building permit, the applicant shall submit for planning board. Say the screen moves. The design and approval of a landscape plan depicting installation of street trees along the property, the frontage. And it lists the 3 parcels. Trees shall be at a minimum of 2.5, I was gonna write 2.5 to 3 inch caliber of time of planting, which is around what, 14 to 16 feet high?
It really varies, depending upon the species of tree.
Yeah.
Mhm. But if it was a maple or an oak, because it needs to be some sort of a buffer. Since we're not doing any other camouflage.
So we planted red maples as part of my street tree project. And they were 1.5 inch caliber, and they were about 10 to 12 feet tall.
That's hard to believe.
Right. I have
I
a
don't know what's
paper.
available I don't even know. I mean, again, know nothing about landscaping, but I don't know what you can get, what maturity you can get. So I'd like to have some flexibility just after we talk to our landscape architect and propose a plan.
I'd just like to give them some minimums that we're thinking 2.5 to 3 inch caliber, minimum of 14 to 16 feet high, and planted at an average spacing of 40 feet. Just so he has an idea, because sometimes landscapers can come back to us and the plant goes up to like your ankle and you're like, well, that's
Mhm.
never gonna grow.
Mm-hmm.
Well, again, we like the condition as it is, and you can take out the 80 feet and just leave it blank, and then it's at your discretion whether you approve the plan or not. So we're not trying to approve, we're not trying to be specific with this plan. We want to have our experts propose something and bring it to you, and then you have full discretion to decide whether that's makes sense or not.
Mm-hmm.
Okay.
Yeah, I'm
So,
fine with that.
Yeah.
Okay. As long as it doesn't come back. That's my, I always get, if you didn't put it in the condition, then it's not gonna
it
stand.
is a pretty broad condition to say we can't do anything until you approve it, so.
Should I leave the bit about planted within 20 feet of the right of way? Is that part okay?
Yeah, that's okay.
Mm-hmm.
And then I'll just say species of street trees and planting interval are subject to planning board review and approval.
Sounds good.
Did you leave in the 2.5 to 3 inch caliber so they know?
I said a minimum of 2.5 inch, so that
Mhm.
means they could be anything greater than that. So it could be 3 feet, 3 inch, 3.5, 4.
Okay.
And we're okay with that.
And then I think further down, you talk about diseased trees are replaced. Or you have to,
Mm-hmm.
Lori, it says the applicant or its successors in interest shall ensure proper maintenance of on-site plantings. I'd like to do plantings/trees, because I don't consider them the same for screening purposes until the time it's decommissioned. Can you do plantings/trees?
Yeah. Yep.
Okay. And that has to do with number 11, and 10 and 11 talk about landscape plans, talking about um minimize visibility. And it's very important because the aesthetics are very important
Mm-hmm. Yeah. And
in that area and every area in town.
well,
And then the
basically, yeah, and but that talks about where it shall be located versus the landscaping around it that once it's located. So, that's kind of getting to what I had originally had a question about is moving it to the other side where it would be, in my mind, located in a far less visible, yeah, okay.
Yeah, and actually when you brought that up, I did bring up adding some pine trees as part of the landscaping plan near where the cell tower is located. So if they couldn't move it to the other side, then the pine trees would be on the other side. So you've got pine trees, then it's in the middle of two clumps of pine trees.
Mm-hmm.
And I think you had agreed to that earlier. So can we add that to the condition about the landscaping, that there will be some pine trees planted to the
Front side of the fence.
west of the tower?
That's already shown on the plan. So
Oh.
I've got that plan if you want me to share it.
Sure.
Oh, let me go to the other page. Just bear with me a minute. I just got out of it, of course.
Yeah, looking at it going,
Ugh, goodness, it's so slow. I'm gonna stop sharing so I can get to it faster.
Oh, I know there were like small arborvitaes around the fencing. I was asking about pine trees on the west side of the parcel itself.
I don't
Like
know.
in the
Which
middle of the crop fields?
no, on the but to the left of the tower, but not on the other parcel. There's a little space there. We had talked about it earlier tonight when Millie was talking about moving the pole to the other side of the pine trees.
mm-hmm.
Yeah, I wasn't quite sure I understood where she was talking about. So I've got it up again, so let me share.
Judy Plon.
I don't know why it's not there.
Actually, oh,
All right. So here are the
Right,
arborvitae. So
Mhm.
I don't, so this is the existing tree line.
right. So if you go
So
to the left,
this is the leased area.
yeah,
mm-hmm.
So
Right
where are you talking about?
the left corner, right at the corner.
Like here,
No, up.
where my arrow is?
Well, here, want me to share a picture?
Sure.
Okay, no, this is a rudimentary drawing.
You're talking about the property line corner? Yeah, okay.
Yeah, see, I was thinking when I was thinking earlier today about maybe a couple pines in the corner there and a couple pines in the corner down there,
Mhm.
but it would buffer. It would just add a little buffer on the property that would eventually grow. So the cell tower would grow amongst the trees, like
Yeah,
the trees are currently over here.
Well, again, I don't want to commit I mean, I just don't know because I just don't know, don't have the expertise. So, I mean, maybe you could just add and propose landscaping to the, I don't know what direction, east to the west of the tower. So we can see what makes sense there. And again, it's at your discretion to approve the plan.
Mm-hmm.
Yeah, Amy, I'm just wondering what you're trying to block there, right? Because that's all farmland to that side of the tower.
Well, this
So,
is farmland over here, right?
right. So what are you trying to block from the view of the tower? The cows being able to see it?
oh
I
no,
No,
don't
from the
I
view of the road.
from the road, like when you, like right now, when you see the crane, you could see these trees and it was
right,
beside the crane. So I was
right.
putting trees on the other side. So if you're
Why?
coming down Ball Street,
You're not
then,
yeah, the ones to the south I can see. Yeah, but the one to the west, you're not blocking the tower.
Well, you are actually, if you look at the picture from a farther out view, because when you come around that corner, you can see that entire piece of property. You can see basically from one corner to the all the way to that the fields to the north of that property. So you can see it. So I think when you come around the corner, if there are like clumps of trees that are sort of one's on the back, one's on the front at the property line, closer to the road, you'll block more of the view. That's and maybe that's something a landscape architect can give better guidance on.
Right.
Yeah,
That's what we'd like, that flexibility to have that
Yeah.
discussion.
yeah. I'm just I just don't see it. I could see it to the south of
Yeah.
the south corner of the leased land.
Mhm.
Sure, but to the north corner,
Well, you can certainly
maybe,
see the trees that are behind the tower. So why wouldn't you see the trees that are in front of the tower? From the photo simulation. You can
okay.
see it.
I just I would have a hard time denying the project, right?
Oh,
Because those pines aren't there,
yeah, yeah,
right?
yeah,
So
yeah,
if that's the case, then we need to be careful what our ask is here on the condition. That's all.
yeah, and this is further down in the landscape plans. I don't think that this is looking for the denial. This is just looking for, if I understand,
Yeah, we
where Amy's
understand.
coming
Yeah, we're
from.
getting an indication of what you're thinking, and we will come back with a proposal.
Yeah, that we would want to be collaborative on.
Right.
Yeah,
Right. Without being any specifics at this point, because
yeah, I agree.
yeah, thank you. That's great.
Okay, I'm just sharing. Okay. That was my rudimentary drawing. All right, so I think we got through all of the 710-040. We don't have to talk about the environmental standards because those are already listed on the conditions. And we have some, okay, and then exemptions, it's not exempted, so there's no reason to go down the exemptions.
Mm-mm.
So I think next, what we have to do is go through, that was 710-040, so we should go through the special permit site plan conditions or criteria, or at least discuss as a board. How do you think? Because we're not really taking any motions yet. Let's have a discussion. Would you, and we kind of already talked about it before, would you,
Wait, where are you, Amy?
I'm going back to 73040 is a special permits, and then the next page is a site plan.
Yeah, I thought
So
you
what
said
we have to
710.
do is talk about the special permit site plan at the local
Mhm.
level. And
Yeah, right here.
would, as a board, would we approve the, as it stands on the local level? And if not, why? So I have the decision criteria for a site plan on page 716.
Mm-hmm.
So I can go down it, or we can just have a general discussion. Like I mentioned before, if you deny for the local level, then we go to the federal criteria. And I think I already mentioned that in my mind, I would deny on the local level because I would stick to our bylaws. I feel like number 5, it talks about reduced visual intrusion by controlling the visibility of parking, storage, or other outdoor service areas. Well, actually, we did that with the trees
Wait,
and the fence.
can you actually bring that up? Because I'm looking at
The
something.
decision criteria for a site plan.
Yeah, I have the new book and I can't find it in there. Or the new book.
I now found the 20, I have all different books out, but page 716, around there.
Yeah, I don't have the 2022 book. I have the like 2024 or something. So,
Okay, I have 2023 now with the
I
site plan.
just got this one, so I don't know where stuff is. Site plans, should be approval. Okay. Wait, special permit site plan approval. Is that, can you post it up or no?
I'd have to find it. I don't have it. I'd
Oh,
have to
okay.
go.
Okay.
Lori, can you
Here it
pull it
is.
up? Oh, you found it, Millie?
And
I think so. Is it reduce clearing and grading?
Yes,
Okay.
starts with that. Do
Got
other
it.
board members, do you have your zoning book? So there's decision criteria to approve a site plan. Given the location, type, and extent of land proposed by the proponent, the design of the building form, building location, grading, other elements. The site plan could not reasonably be altered to, and number 1 is reduce clearing. And I had asked before, and they said there was going to be no clearing, so.
So that's a yes.
And that's a reason why it's actually, in my opinion, this location, I looked around this location to see what some towns do is if if there's residential pushback on the location. I went and I looked at Green Street, Ball Street, and Smith Road to see if there are any if there's any town-owned land.
Mm-hmm.
And there was only one little space of town-owned land, which is right in front of Davidians. It's called a school lot.
Right.
And it's very small and it's closer to the road. So I feel like that would be actually worse for aesthetics and for the neighbors. And other than that, the other property in that area that isn't private was conservation land. And I think it's hard to get a site out of conservation land to put up a cell tower. And if you did that, they would have to cut down trees in the conservation land. So for that reason, you know, this site, you don't have to reduce clearing grading,
Thank you.
at least in my opinion.
Mm-hmm.
So if we go through the decision criteria, did anyone feel they could reduce the clearing or grading on the site?
I do not.
Yeah, I think that was fine. Reduce the risk of groundwater contamination. It looks like there shouldn't be any contamination coming from this, but Lori did have a condition about no contamination. And then number 3, improve pedestrian, bicycle, vehicular safety on the site and egressing from it. I don't think there's going to be one car every now and then. So I don't see a problem with safety there as far as pedestrians and bicycles.
Right.
Improve access for fire and other emergency service. I think, did the fire and police look at it as far as being able to get in and out if they needed to? I think they usually do for our plants. Do
I
you know,
didn't see
Lori?
anything from them.
Sorry, I was having technical difficulty. Here we are.
Do you know if the fire and police had any exception to this area for fire and emergency service equipment?
No.
No, you don't know, or no, they did not.
They provided me with letters, and the letters had to do with only being interested in access for their equipment. So they didn't have any other issues with the design.
Okay.
Okay, so number 5 was reduce visual intrusion, visibility of parking, storage, or other outdoor service areas. So I think the fencing and the trees did reduce the visual intrusion of those, but not the pole. I mean, I don't think you can't really mask 130-foot, monopole. But as far as parking, storage, and the equipment, it's now an 8-foot cedar fence, so that should contain all of the equipment. So number 6 for the decision criteria for site plan is achieve greater consistency and compatibility with the surrounding area as to the building design, scale, or site design.
I'm not sure I am in line with that one.
I agree. I don't think they met that because it's 130-foot
Right.
pole. So, yeah. That's on the local level. So that goes back to, there are things on the local level that I would feel required denial on the local level, but then we would have to look at it from the federal level. So number 7,
Yeah.
oh, does anyone else want to say anything?
No, I
No.
agree with both of you.
Number 7, reduce glare from headlights, light trespass. We just talked about that with the lighting.
Mm-hmm.
So I think we're all set there. Avoid the removal or disruption of historic, traditional, or significant structures. We're not removing any structures.
No.
Number 9, reduce obstruction of scenic views from the publicly accessible location.
So if it determines that of this bylaw, which is reducing obstruction of scenic views, I don't think it obstructs scenic views. Well,
Right.
it is an obstruction in the scenic view,
Right.
so I don't know really.
Yeah, it's almost like the trees that we're asking them to plant are the obstruction
That
of the scenic
actually
view.
was what I'm like, wait, what?
Right.
But they also make it more in aesthetic, yeah.
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 Right.
So that's, does it reduce the obstruction? It's weirdly odd, yeah.
Just wanna,
Yeah, I don't know about that one.
like you said, itself is not the obstruction. I
It
just wanna,
reduces the enjoyment of a scenic view, but not the obstruction, which in some ways. But the trees would be part of a scenic view to hide the obstruction or to hide. Okay, never mind.
right. Lori, I'm just gonna, it says I can replace your current chair. I just want to share something really fast. So this is going down Ball Street, and this is why I think I think the trees are important, the street trees, though. That's what Ball Street looks like, and on the other end, it has no trees. So, I don't know. But like you said, reduce obstruction of scenic views from the public access location. Well, I don't see a problem with that. So my only
No.
problem was building design scale or site design. I feel like the
Yeah.
pole should come down in height because it's not compatible to the surrounding area
Yep.
because it's 130 feet and our bylaws call for 75. So again, I feel like I would deny the waiver locally because I feel like it doesn't meet our bylaws, but I feel like the waiver I would approve federally because I feel like they showed that they needed it. And I don't know how other board members feel.
Hmm.
Same.
Did Millie or Bill have anything about?
Are we,
Right.
is this the end of our decision criteria
No.
discussion or?
Well, that's the end of
Yeah.
the site plan. We can go through the special permit too if you want, and then we can keep discussing. We're not really,
Yeah.
okay. So I'll go through the site plan. I mean, special permit, that is in my book on page 713. So for number one, the proposal is in substantial harmony with the Northborough Master Plan and other plans as approved from time to time.
I'm not necessarily in agreement with that one. A big piece of the master plan is the, um, you know, scenic parts of Northborough, the tourism, and I don't think this is in harmony with that.
Bill and Anthony?
I agree with that.
I don't agree with that only because, and I know I've already been called out twice on this, but the ability to be able to get to and from places like Davidian using GPS, right, adds to the ability to be able to provide access to those locations. And, being able to use your phone's GPS, because we can't talk about the Wi-Fi or public Wi-Fi, it, according to the master plan, it adds economic benefit to me, in my eyes anyways, but that's just my opinion.
Mm-hmm.
I can see both in a way. I see that economic development was part of it, but I also the major part of the master plan is keeping with the character of the town and the aesthetics. That's a main part, and it talks about natural features. So, I actually, the majority of it, I don't think is in agreement with the master plan, but I can see that what you're saying too. Number two, the proposed site is an appropriate location for such use.
I do agree with the use.
Yeah, it's a tricky one because I don't think it's an appropriate location because it's in residential. But I do
But
think
cell
that
tower-
they showed that it can't be an industrial because it's too far away.
Right.
commercial.
Yeah.
Cell towers are allowed in residential.
Mm-hmm.
So we already have that in our bylaws. They're allowed. We already have one, what, 400 feet away, effectively.
Mm-hmm. Yeah.
The
So it's
use
inappropriate.
for me.
Yeah. For me, I would rather have it in industrial and commercial, but I feel that they showed that, like I said, you can't do it because it's too far away, unfortunately.
Yeah, my only issue with the site is whether it was vetted for the other side of those trees, but that was it.
Mm-hmm.
And I didn't see that it was, but that doesn't mean it wasn't.
How about number three, the uses developed will not adversely affect the neighborhood.
I'm gonna disagree with that one. I feel like the fair market value that was done was actually not an accurate representation, whether or not the property values are gonna change, because they didn't take into account that, number one, this is a scenic road designation. I don't think that any of their I don't think any of their examples were posed on scenic roads. And I don't think any of their examples gave a before cell tower installation versus after cell tower installation, which is when you really see the market value drop. Other than that, it stays relative to what it already is. So I don't agree with that one at all. I think that this does have an adverse effect on the neighborhood.
Bill and Anthony?
I agree with that.
Bill?
Yeah, I, I don't know. We have a cell tower in, close to other residential areas,
Mm-hmm.
and that I know of, they're all within the median price of the town, right? They haven't gone up or down because of those cell towers. In fact, most people don't even know they're there.
And I agree with you on Bill, but those aren't comparison values between before the cell tower came in. Do you really think your property value would be the same if a cell tower of what you bought it for and what you need to sell it for, if a cell tower came right next to your neighborhood? I
Yeah,
think you would see, I
I
think you would see a
I
difference.
actually think mine would. And here's no,
Well,
but
mine
yeah,
would, because I
but
don't have cell tower communication in my house, but
but you have to remember
yeah,
that I work in technology,
sure, sure.
right? And so for me, I would be willing to pay more money if, because right now my house is a dead zone, right?
Doesn't,
I pull into my yard.
yeah,
I've been on the phone many times, and I
yeah,
go to pull in my driveway and my call literally drops,
yeah.
right? Not just static, drops. And for me, that's an annoyance, but that's me, right? I'm not saying that that's everybody. So I would be willing to pay a little more to know that my cell phone's going to work,
Well,
whether
not,
I'm in the house on Wi-Fi or outside in my yard mowing the lawn.
yeah, so you would pay more for a house to know that, because with a cell tower nearby. But I'm just curious if you think your house value would improve, stay the same, or be
I think
affected.
it would stay the same. I,
I don't think it would, but
You
anyway,
asked what my opinion was.
no, I
That's my
appreciate that.
opinion because
I,
I think there are people out there who are willing to pay to have good cell coverage.
mm, don't know if that.
What I read,
I think it's the NIMBY effect on that one, but you don't have that clearly. Anyways, I
Right.
appreciate that. Thank you, Bill.
what I read is the National Association of Realtors, and they use other studies, is that your house price may or may not, it would be affected because you wouldn't have as many people looking at it. Like where you might have 100 people come through to look at it, you would most likely get like 30 because there would be people interested in better cell service, but there are a lot of people who may look the other way because they don't want a cell tower near their house.
Right, but I'm actually asking for a market value of a house before and after, and I didn't see that in their study. I saw comparison houses in different places, but I don't know what their circumstances were, whether, you know, that's not really, in my mind, an accurate representation of whether or not your house values are affected. The accurate representation to me is whether I have my house today, it's worth X amount, cell towers going in tomorrow, what happens then? And I do think there's a drop.
Yeah, I don't know if anyone's ever done a study like that. But okay. So in our opinion, there were a couple of people who thought it would adversely affect the neighborhood, and then Bill thought it wouldn't. So number 4, there'll be no nuisance or serious hazard to vehicles or pedestrians. I don't think there will be because there's only one car coming back and forth every now and then.
Agree.
Anybody okay. Anyone disagree?
No, I don't disagree.
Okay, adequate and appropriate facilities will be provided for the proper operation of the proposed use. I do feel that they showed that.
Yep.
Anyone disagree?
No. Nope.
I don't disagree.
Okay. Number 6, the proposed use will conform to any special requirements of the special permit granting authority as stated in its written decision. I feel that's give and take. Like, I feel like conditions that we've discussed, like as a board, I think we're working with the applicant on conditions, so it's not like we're throwing on conditions that they don't already know about. So I guess that's a hard one. Because they did say they would conform though to the conditions that we have set forth. So I guess they would, unless we threw something random on there. Number 7, the proposal could not reasonably be altered to reduce adverse impact on the natural environment to be compatible with the historical development patterns of the town or preserve historically significant buildings.
I mean, I don't think that really applies here. Altered to reduce advert on the natural environment. Well, yeah, I don't think so.
Right. It's more scenic than environment. A
Yeah,
historic development, it's not a historic, but historically that has been farmland.
Yeah,
But
but
there's no historically significant buildings.
yeah, they're not historically, yeah.
Okay. So for the special permit, so the special permit and site plan, as a board, I guess we had 2 waivers too. The waiver for the setbacks, we agreed that those were fine, the setback from the lot line and the
Mhm.
house. So the second waiver was for the height of the tower.
Mhm.
And like I've said 3 times probably already, locally, I would deny the waiver on the height because I think we should look at Northborough and stick with our bylaws.
Mhm.
But if I have to look at the federal regulations that talk about significant gap, then I feel that they met the requirement. So overall, federally, I would have to approve it as much as locally, I would not want to. if we could vote to deny just locally, I would deny it. But if we have to approve it due to the federal criteria, then I feel that with the information that I've heard and after talking to the peer reviewer, that I would approve the waiver for height, unfortunately.
So the approval of the, let me,
So these are the two waivers.
which height is this waiver now on? Is it the 110 feet with a 20-foot condition? Or is it 135 feet carte blanche?
Well, it's 130 feet with a 5-foot lightning rod,
Yeah,
but what they're asking for as the condition. So I think if we did do a motion, correct me if I'm wrong, Attorney Stein, but if we did do a motion, the motion is for 130 feet, but the condition says that it's 110 feet. I'd have to pull up the condition exactly now to see what it says.
It's 110 feet plus the 20 feet for the Spectrum Act.
So,
Okay.
so I actually, and maybe this is something you want to confirm with the applicant, but I had actually thought that you were going to approve a 110-foot tower
Okay.
with a 5-foot antenna, and
Okay.
then have the condition just state that the board understands they've approved essentially 110 feet with a 5-foot antenna, that the applicant can automatically, exercising their Spectrum Act rights, extend to 130 feet with a 5-foot antenna for a total of 135 feet.
Okay.
And-
And would it
and-
be 5-foot antenna or a 5-foot lightning rod? I think. Because it's not really an antenna, it's a lightning rod.
I defer to you.
So
Oh, I mean, I think I defer to either you or Michael for the right terminology on that, but
just to clarify,
for the applicant,
we
for the right
approved the
terminology.
motion, but not the condition. If one person were to say this, motion, I accept the 110 feet or whatever that is, but I don't approve the condition, how does that affect the decision?
Well, the motion includes the conditions.
Sorry, so I think,
Mm,
yeah, I think
Yeah.
the ultimate motion would say subject to the following conditions. So the motion is going to include the condition. It's all. So ultimately, at some point tonight, you're going to have one, maybe a series of motions
yeah.
to whether you're approving under the local bylaw, whether you're approving under TCA, but each of those motions are going to be subject to your conditions. So you probably should run through the conditions at some point and make sure you're all on the same page with those.
Yeah.
But the way that I envisioned it is that the motion would be for approval of 110-foot tower with the 5-foot lightning rod, I guess.
Yeah.
And what really is 3 waivers, 2 for setbacks, 1 for height, the special permit and the site plan approval, subject to the, conditions that you should review and finalize.
Mm-hmm.
And then you can vote it under the local bylaw. You can, you could break that up even. It's really how you want to vote it, how the board feels like they want to vote. You can vote it under the federal. And then I think you're probably going to need one more final motion to, and I don't want to go too far here, but I think you're going to need a final motion that's something along the lines of adopting the findings that are already set forth in your draft decision that are actually consistent with your votes and your statements tonight, and to incorporate additional findings and reasons that you've stated during your deliberations tonight, and then authorizing a board member to work with Lori to actually have the authority to finish writing up the decision and filing it. Because there's a lot in your draft decision that I think you want to keep, but there's clearly some things in there that are probably not going to be consistent with your ultimate votes. And so I do think you want to, whether you go through the draft decision or whether you just do it that way, so we tie everything up. But I do think that before you vote, and I don't know if this is the right time or not, you should run through these draft decisions because you've talked about making changes to them even as we've discussed tonight. And I think as a board, you want to make sure you're all on the same page with the conditions. And I know Amy had some suggested language changes. I know the applicant had one suggested language change to the conditions. So I do think you need to do that before you vote.
Okay, so we should do it now.
So just to clarify,
If
again,
that's
I don't know
helpful.
why I'm hung up on this,
And
but,
it doesn't, I mean,
so if it were to
I'm
be
sorry, who is
voted,
it? Is Millie? Oh, sorry, I just couldn't tell who was talking.
oh, sorry, I didn't realize somebody else was talking. So just to
Sorry, go
clarify,
ahead.
it's Millie. Just to clarify what the vote looks like, if the motion is made to vote for the 110-foot tower with a 5-foot antenna, and the invoking the Spectrum Act, the maximum height of this tower would be 135 feet. If it were to be voted that the 110-foot tower with the 5-foot antenna with no condition, what might that look like? Because they could use the Spectrum Act at any time, correct? They could still use it.
Yeah, I mean, I think you get to the
risk.
I think you get to the same place either way.
I agree.
We're approving 110-foot. And they know they can go another 20 feet, which they plan to do. And
Right,
make 5 foot on top of that.
right. But what if so I don't understand
And
the
I,
point of the
just to clarify, I don't hear the applicant,
they can do it anyways.
because
I'm
it just
not-
makes it very, very clear that they've already
Yeah,
exercised their spectrum rights.
right. I think it's more important to make it clear that they've exercised
and
their
I don't
rights.
hear the applicant of, you know, I don't think the applicant's objecting to the motion being presented that way with the
No.
condition. And personally, in my opinion, that's the best way to ensure that you incorporate what you're trying to accomplish.
Yeah. And what I would hate to do is to do all of this work, right? And then try to undercut
Mhm.
the applicant, right? The applicant has been very helpful to us and has agreed to this already. So now for us at the last minute to try to undercut them, I think it is bad form,
Yeah,
to
no,
be
I
honest.
don't, this isn't an undercut. This is to me I'm trying to understand the point of doing a condition that they can already do. And if I understand now that it's to limit them from doing something differently some point, I don't know what that would be. They can do it. So
Yeah,
if we approve the 110-foot tower with a 5-foot antenna, they can invoke the Spectrum Act and get a 135. Maybe they'll get, I don't know, is the risk that they're going to get more?
No, because they're already
No.
invoking it. The
Well,
problem
the
here,
point of the
I
condition
know,
is
I'm
that
saying
it,
if we don't approve, if the condition is not included, is the risk that they're going to ask for more than the 20 feet?
No, because you
No.
can't under the Spectrum Act. We're limited.
Right.
That's why we're agreeing to that now.
Well, you're agreeing to something you can already do. Is that correct?
but
Oh,
but
the
it requires
condition-
them to come back.
But
It requires them to
just
have
the-
to come back and go through all of this all over again with the building inspector, right? They're bypassing that. We're helping them bypass that.
With
Yeah,
the 20,
we're giving up our right to go from 130 to 150, you know, because you're concerned about that. And even if we said there aren't other carriers out there, there's no chance, you're not going to believe that. So we're saying, okay, let's backdoor it this way and say, okay, let's go from 110 and then exercise it now to go to the 130. So there's no chance that we could come back and ask for 130 to go to 150.
Mhm.
that's the way I looked at it starting is this
Yeah, and
was
when you-
because we were asking about if they could go up 20 feet. So this was,
Okay.
all right, we'll come down 20 feet and go up 20 feet and say that we won't go up another 20 feet. So it's not going to
Technically,
150.
You're still going to get what they're originally asking for, which is Twice the
Without
height.
your concern about us being able to come back and ask for, go up to 150. We're
Right.
eliminating that right here tonight.
Mm-hmm.
The
But you're
point
still,
of
yeah.
order, the public hearing has been closed and the residents have been told that we may observe but not participate.
Right.
Why
It is a point of order.
Why is
Sorry.
the applicant allowed to provide information and
I just-
influence the vote? I respectfully request that if applicant continues to participate, that the residents are also equally allowed to participate. Thank you.
Thanks. As part of the deliberations, because we left the public hearing open, we're allowed to ask them questions, and that's why we left the public hearing open, but it's not open to any more new input, and that's why we're not taking residents' comments. It's just for us to be able to ask town council or Mike Lawton or even the applicant questions.
Thank you. The applicant has been volunteering information and the whole bargaining about the distance of the trees. This was not a response to your questions. Thank you.
Okay.
Okay, so, Millie, is it kind of clear? Is it?
Yeah, I think it's an odd presentation, but yeah, it's clear.
All right, and we can go over it again, but should we go over the conditions? Lori has pulled them up. I can't, I guess I gotta make it. I'm trying to see my conditions and yours, Lori. Does everybody see Lori's as pretty small? Or is it
I
just
don't know
me?
which ones yours or Lori's.
Is there any way to make yours bigger, Lori?
It looks really big on my screen, but
It looks fine on
needs
mine,
to-
I think.
Okay. I guess because I'm
There you
trying to
go.
put it side by side, I want to see your conditions and my conditions, and I just see yours as super small. I can't even read them. But if everybody else can see them, it must be me. So maybe if we read them out loud.
You want me to read them? The applicant shall comply with all applicable bylaws, rules, regulations, codes, and obtain all necessary permits and approvals.
Mhm.
Prior to issuance of a building permit, the applicant shall submit for planning board review and approval a landscape plan depicting installation of street trees along the property frontage of 321 Ball Street frontage only, 351 Ball Street and 409 Green Street. Street trees shall be a minimum of 2.5-inch caliper at time of planting and planted at an average spacing of 80 feet within 20 feet of the Ball Street and Green Street rights of way. You did discuss changing the language to
Yeah, I wanted to
remove
take out the 80.
at an average spacing of 80 feet. So that phrase would be stricken. The rest would remain. Existing street trees where present and healthy shall be retained. Species of street trees and spacing interval are subject to planning board review and approval. So, and spacing interval was added to that one.
But Lori, on that one, when you're taking out planted at an average spacing of 80 feet, I had in my notes just from the conversation earlier that it was going to say planted at a distance to be approved by the planning board instead of an average spacing of 20 feet.
So what I did is I got rid of that. So it says planted.
Okay.
But does it still say to be approved
So
by the
it
planning
says
board?
planted within 20 feet of the Ball Street and Green Street rights of way. And then the last sentence says species of street trees and spacing, oops,
Oh, okay.
spacing
Gotcha.
interval are subject to planning board review and approval.
Mhm.
Perfect.
Can you add the little thing about, also the discussion about the pine trees on 409 Green?
Is that the consensus of the board that you want that?
No, I think it should be a discussion later
Discussion.
on.
Yeah.
Right, but it
Discussion
should
about-
be,
It shouldn't
in-
be in the conditions
well, when are we gonna discuss it later?
When they come back for
when they come
review
back for review.
or before their building permit, but I mean, before their, yeah.
But it has to be in the condition that, you know, pine trees shall be discussed when it comes back. If it's not in the condition, then it's not gonna be discussed again.
You just won't approve our plan if you don't like it.
Yeah, but I just wanted to mention the pine trees on 409 to be considered. So then we can discuss it when it comes back. If it's not listed here, the landscaper isn't gonna know about it.
No, we'll tell them. We took notes. We know exactly what you were showing.
Can we put it just so we remember?
Right. Right, I think it should be in there
And
that,
just
you know, the applicant will discuss pine trees.
How about installation of screening pine trees?
And street
of,
trees on to be discussed.
Screening.
Yeah.
Pine trees on 409 Green Street and street trees
Can you
along
say
the property
possible?
frontage.
Possible, including possible screening of pine trees. So again, if we don't know the viability of all that until we talk to our landscaper. So this will remind you that this is something that you wanted.
Right,
Yeah.
but what if you come
Lori,
back and,
instead of putting it in that sentence, because I don't want it. Well, I was just gonna say, instead of putting it in that part of the sentence, because I don't want it to sound like the screening on those streets is possible. Maybe just add a sentence that says, discussion of the landscape plan shall include a discussion of, potential pine trees or something, just that it's gonna be part of the discussion.
That's fine.
Is this somewhere where we also want to add about the time frame or no?
Well, the time frames prior to the issuance of a building permit, so that before they get a building permit, they have to come in and get their plan approved, and their plan is gonna say when they're gonna do everything.
When everything will be done by?
That's
Agreed.
part of the landscape plan itself. It's like, it's
We
gonna
agree.
have,
Yeah.
and when you approve it, you're gonna make sure of that it has in it the timing of accomplishing the landscape plan.
Okay.
Yes, that's right.
How's this? Potential installation of screening pine trees will be discussed at this time. Should I say on the property of 409?
in the area of the cell tower.
Oh, yeah, I'll fix that. Is that good? My wordsmith that a little bit.
Attorney Stein will have to read it. I can't read that.
It says potential installation of screening pine trees in the area of the cell tower will be discussed at this time.
Okay.
Next.
I think that's fine.
Next one is prior to issuance of a building permit. The applicant shall provide copies of written agreements with all applicable parties or other adequate documentation that is authorized to, 1, relocate the town of Boylston's existing public safety telecommunications equipment and the Davidian Farms existing telecommunications equipment, all ground and pole mounted equipment from 351 Ball Street onto the new monopole and the property. And 2, remove those 2 existing monopoles from 351 Ball Street.
And the next one is within 90 days of, I have that. So I have yours with mine added in. If it didn't change, we don't have to read it. Unless somebody wants it to be read.
And nobody has your changes, Amy.
Right. But I have your original. We don't have any changes to the within 90 days of the
So do you
moving.
just want to skip over and just have me read the ones that you want to change?
Well, I mean, I think we can say like the next 2 we've already discussed, and if everybody's in agreement with them, everybody can read 5 and 6. And are
Okay.
you in agreement? Or 4 and 5?
4 and 5.
Yep.
Only because I added something. I added 3. I wrote, if the monopole is choice, I added about a non-reflective material. Is there any?
I put that in the findings of fact about it being galvanized. So it's not a condition. It's in the findings.
But we might have to have a condition that it's a non-reflective. Is galvanized
Honestly, I
non-reflective?
think you can,
It is non-reflective. So the finding says the
I mean, you
monopole
can add that.
antennas and antenna support structures will have a galvanized steel finish. I can add, I mean, it is non-reflective, but if you want me to
I think we should have it a
say that
condition.
again, I can say that is non-reflective.
But I think it has to be a condition, right? Because it's,
I mean, Lori, I think you can add that as a condition at the end, but without complicating and fitting it into any of these conditions, I think you could just make it like condition 20. Just to say that it'll be galvanized, non-reflective. You can just repeat it as a condition and that way it's clearly in there. It can just be its own condition.
Okay, the next one, the applicant submitted a change that they wanted to see, which is tracked in the text here. So their proposed change, and so I'll read the original condition and then identify their proposed change. So the applicant shall in perpetuity reserve space for and allow the town to install and use on the monopole and within the equipment compound for the town of Northborough public safety telecommunications equipment at no charge to the town. The applicant shall provide the town of Northborough with access to metered grid power at no charge to the town. So they want to add the language. The applicant shall in perpetuity, but only if the monopole is still erected at the property and used by at least one other tenant of the applicant or any successor in interest to applicant. So they want this language that specifies that the pole still exists on the property and that they have a co-locator other than themselves, Verizon.
because I'm assuming if they don't have any co-locators, then they take the pole down.
That's correct. So otherwise we're leaving it up just for the town.
So I understand that to mean that it would be Verizon and one other co-locator. Is that incorrect?
No, just one co-locate, just one tenant.
Well, it says
So
one
it says,
other tenant.
Well,
yeah,
you can take out other, meaning.
Yeah,
one
take out
tenant.
other.
You can take out other.
Okay.
okay. Yeah, that was going to be my question as well when I saw
Yeah.
the other.
Yeah.
Okay. So
Yeah,
you guys
because-
are okay with that one?
Yeah, because what we want is if they're not using it, they take it down,
Right.
Mhm.
right? So, if we're going to ask that, then we have to be able to do this. So I'm
Right.
fine with that.
Perpetuity is a long time.
Not in zoning world, it's not.
Okay, so number 7, any comments on that one?
No,
No,
Number 8, about signage. Number 9 is noise.
and then I added something to the noise.
Yeah, but the test should only be done in the daytime.
Yeah, let me see.
Do you want to read specifically what you added?
What I saw in another town was non-emergency diagnostic testing of the backup generator shall be strictly prohibited on weekends and federal holidays and may only occur between 9 a.m. and 5 p.m. Monday through Friday.
Okay, can you do that again slower?
Sure, sorry.
Non-emergency diagnostic testing.
Of the backup generator
Got it?
shall be prohibited on weekends and federal holidays. And may only occur between 9 a.m. and 5 p.m. Monday through Friday. But what this one said, and shall be limited to a maximum duration of 30 minutes per week. Like how long does these backup generators go? Because you wouldn't want the testing to go from 9 to 5 Monday through Friday.
I don't
Is
know
there
if it's
like
30 minutes or 60 minutes. I don't know if Carrie knows exactly how long, but I wouldn't want to have it wrong
Yeah,
here.
it's between 30 and 60 minutes. I think it's 30. I would have to confirm
Yeah,
with
well,
my
maybe we
team.
could just say no more than 60 because I
Yeah.
don't want to be wrong.
this says and shall be limited to a maximum duration of, it said 30, but you can put 60 minutes per week. The main intent is that the backup generator, unless it's an emergency, isn't running all day long.
Okay, so I have non-emergency diagnostic testing of the backup generator shall be prohibited on weekends and federal holidays and may only occur between 9 a.m. and 5 p.m. Monday through Friday and shall be limited to a maximum of 60 minutes per week. That's good?
Mhm.
Okay.
Now, do we have, I know we have, they also had it, no time shall be the cumulative sound output exceed 45 dBA between 9 and 7. But is that already in our bylaws? Like there's a maximum sound?
It does say 40 dBA, but I believe Mike Lawton had suggested, or it might have been Robin who had suggested limiting it to 10 dB.
Oh, okay. The other one was cumulative. All right. The other
Well,
one was
I mean, if your
including other
bylaw
things.
has if your bylaw has a specific requirement, though, I think I would just go with whatever your bylaw says. The 10 dB comes from the Mass DEP's definition of noise pollution, but um, it's up to you.
Mike Lawton, do you know what the sound is usually, or maybe you don't? Maybe
I'm
you're not
sorry,
here.
I don't know, I don't know the specific standard, but I do think that you would want to adjust the first sentence of this condition so that in the event of an emergency, the generator could run and violate the noise standard, because in the event of an emergency, you do want that generator running.
Did I say non-emergency diagnostic testing or
Yeah,
no?
that's in the second
Okay.
sentence. Maybe what I'm suggesting is maybe just put that phrase at the beginning of the condition so that it applies to the entire condition rather than to just the testing. because I think in the event of an extended power outage, I would imagine people's home generators are going to be chugging
Right,
away too. So
right.
How about if I just these out into two separate conditions?
we do that too, but I do think the first one should also say,
Sorry.
non-emergency noise generated or non-emergency operation of the uh, ground of the generator. Because really, I mean, it says the ground mounted equipment, but there's really nothing else that's creating substantial
Or you
noise.
can say when not in use.
Yeah,
So when generator not in use,
So,
noise
well,
generated.
this has to do with the ground mounted equipment. It doesn't have to do with the generator.
well, the generator is ground mounted equipment. And typically the radio cabinets do not make noise. The days when carriers used to put their equipment inside um, uh, concrete shelters with big Marvair chiller units that made a racket, that they don't do that anymore. It's all self-contained cabinets with air handlers on the top of them that are much quieter and are not industrial air conditioners.
I guess I'm kind of confused with what you're saying, because if the sentence is noise generated by the ground mounted equipment shall not exceed 10 dB, that would include the generator. So I don't know why we would add.
What I'm saying is, I think that when the generator is running, you don't want to hold them to that standard.
Right.
Because if the generator is running because of an emergency, it's going to make noise and it's going to raise the level of the sound above 10 dB.
So he's just adding non-emergency in front
Yeah,
of noise.
that's right.
Does that make sense?
How about this?
Emergency.
During the non-emergency operation, it should be here.
There's something in the first line that needs to be fixed.
So this needs to come out. So noise generated by the ground mounted equipment associated with the FWCF during non-emergency operation shall not exceed 10 dB above ambient measured at the lot line of the subject property. So that's how that first sentence will read.
Take myself off of mute and say that covers it.
Because I think just putting non-emergency at the beginning made sense too. Like, I guess now it's free.
Where does the 10 dB come from? Because is there, if there is already a regulation, shouldn't we just comply with the town regulation?
Yes.
See what our
Yeah,
regulations
so
are.
Massachusetts Department, just to clarify, the Mass DEP standard for noise pollution talks about 10 dB above ambient. Now, your bylaw says it's in 7, 10, 40, let's see, I think G2 says ground mounted equipment for a WCF shall not generate noise in such concentrations and of such duration as to be greater than 50 dB at any audible frequency. So it's a little bit different, and you might want to just go with what your bylaw says. It's up to you. So your bylaw says 10 dB at any audible frequency.
I don't know the difference.
Well, one's relative to ambient noise, which is the noise that's out there in the field today, and the other one is an absolute value.
Yes.
So would you go with our bylaw?
It's really-
Is that what you're saying?
I think either one is fine, as long as the condition doesn't affect the operation when the generator needs to be operational. Permanently, not permanently, but operational for other than testing.
I agree. I just don't know how to write it.
I would say this is fine. If the applicant's fine with it, and I think this covers it.
You know, it's measuring 50 dB or 55 dB, the ambient already be greater than.
Yeah.
50 dB.
Sorry, I'm talking to my husband, who's a professor of noise at UMass.
Not really, but
What do you think? What are you saying?
I don't know. I don't know what
Oh, we have to,
what's the ordinance say?
the ordinance says 50, what is this? What does the ordinance say again?
The ordinance says it can't be greater than 50 dB at any audible frequency measured at the WCF property line.
50 dB at any audible frequency. That is it.
That's not good.
That's not.
He said that's not good.
What is that?
Or 10 dB above ambient.
Yeah.
That's easier to measure and reasonable.
50 dB at any audible frequency could be like that, like you could end up with 100 decibels that way.
Okay. He just said that was
The first one is uninterpretable.
uninterpretable, he said, your bylaws. Just so you know,
Yeah.
but 10 dB is reasonable,
10 dB
above ambient.
So you're just gonna leave it.
He said that's
You're gonna
reasonable,
leave it the way it is.
and that is what DEP is, you said?
Then you would start to notice it. It's not perfect, but it's
All
better.
right, he said that was better.
I can think of that.
Okay.
All right, so the next condition has to do with the bond. At one point, we were talking about 40,000. I do not have an amount in this condition, so it says prior to issuance of a certificate of completion per, then I say the section number. The applicant shall provide a bond in a form acceptable to the planning board, or shall place into escrow a sum of money sufficient to cover the costs of removing the WCF from the subject property, and furthermore, said fund shall be held by the town treasurer or an independent escrow agent to be appointed by the carrier and the planning board. Do you want to leave that one as is?
Yeah, we reviewed that. That was okay.
All right, so number 11, any comments on that one? That has to do with giving the town the written authorization to enter the property to remove the WCF if the applicant falls down on the job. So they have 90 days to remove it from the date of abandonment or discontinuance. Any comments on that one?
No. Okay.
No.
Number 12 is emergency contact information to the building inspector and the planning director. 13 is the submission of radio frequency radiation information to the planning director and the building inspector within 90 days of beginning operations and at annual intervals on January 1st.
I think the next few, we already, well, I don't know if the board read, but I think the applicant read and I read.
Number 14. This approval is for the tower and Verizon only as proposed. Any additional co-locators need to come to the town for approval.
Mm-hmm.
Yep.
Okay. 15, it has to do with verifying that they're in compliance with noise standards.
Mhm.
16 is a structural engineer will perform a structural safety inspection every 2
Mhm.
years and provide a report to the building inspector and the planning director on July 1st. 17 is maintenance of on-site plantings. And you folks talked about adding language about the wall. I mean, yeah, the fencing.
And I said plantings and trees, like plantings / trees. Because sometimes I read plantings and since I'm not a landscaper, I would think of that as flowers and bushes. But I want to include the trees too.
Okay, so now it says ensure proper maintenance of on-site plantings, including trees and the fencing for screening purposes. The next one is
Was it supposed to say that like broken or falling apart fencing shall be replaced?
well, it's not that specific. It just says proper maintenance of on-site plantings, including trees and the fencing.
But I think there should be something like if the fencing's falling apart, it should be replaced or fixed within, 3 or 6 months.
Uh,
And hopefully it will never be falling apart.
and deteriorated fencing. Fencing.
I would say
Shall,
broken because deteriorated is kind of, I don't know.
oh, it can be falling over, but not broken. How about broken, deteriorated fencing shall be replaced
Mhm.
within, what do you want to say, 30 days?
Or 90, we have 30, 60, 90. We had 90 for other things because I don't know how long it would take
Again,
them to get out.
weather permit, because of weather, I'd do 90.
Okay. 18, the project shall be used and constructed in substantial conformance with this decision, the application, and final plans.
Mhm.
Any substantial modifications shall be subject to planning board review and approval. It's our standard condition that we have. 19 is the
So
monopole.
Lori, I think this last night,
I'm sorry?
yeah, I think this one needs to be adjusted just based on the prior conversation. So
18 needs to be adjusted.
can I suggest, no, 19.
Yeah, this one says the monopole with the
So-
antenna is approved to be 115 feet.
110.
What I think the issue is the width antenna part. So maybe for clarity, it would say the monopole is approved to be 110 feet with an additional 5-foot lightning rod and may be extended at the time of initial construction to the height of 130 feet with the additional 5-foot lightning rod for a total of 135 feet pursuant to the so-called Spectrum Act, and then the rest of it can stay the same. Does that make sense?
Okay. The monopole, you're gonna have to go slower, is approved to be 110 feet.
Sure, I'll do it again. So
tall with an additional
Yep.
5 foot tall lightning rod and may be extended at the time of initial construction to the height of 135 feet pursuant to the so-called Spectrum Act.
130 feet.
Yeah.
I would say
And
to 130 feet with the additional 5 foot lightning rod for a total of 135 feet.
For a total of 135 feet?
Yes.
Because
I
it
think
includes the
that's
lightning
what
rod.
makes sense, but if that's wrong,
Can you read it again? I just can't see it.
It does
you
make
want me to read it,
sense.
Lori,
The
or you
only
got
thing
it?
I would add, I would suggest you add is a comma after the word rod in the first line.
There?
Sure. So it reads, the monopole is approved to be 110 feet tall with an additional 5 foot tall lightning rod and may be extended at the time of initial construction to the height of 130 feet with an additional 5 foot tall lightning rod for a total of 135 feet pursuant to the so-called Spectrum Act. And then the rest of it stays the same. The applicant acknowledged to the board at the public hearing that this height increase constitutes an eligible facilities request and that any further increase in the height of the tower will require approval pursuant to the town's then applicable rules, regulations, and bylaws. And then the only other note I had from earlier, and I don't know if you want to add this or not. Oh, actually, I think you already took care of it. You're going to add a condition about the pole being galvanized metal and non-reflective, Lori, right? So they'll have that as a 20th condition. Okay. That was the only other comment I had
And then
from
didn't I
just the
have one
discussion
about the
earlier.
lighting? The lighting shall be, if the lighting's gonna be automatically go on, that it's gonna be, focused inside the enclosure. I had mine said lighting shall be cranked out, but you guys said that it's gonna be motion censored. So the motion censored lighting shall be pointed
Uh,
inside the enclosure, the equipment enclosure. Pointed down.
I'm still on 20. So you want to add
Okay.
21?
Mm-hmm.
Lighting shall be aimed at the ground.
It's inside the enclosure.
Lighting inside the enclosure shall be aimed at the ground.
Yeah, all the lighting shall be focused inside the enclosure, facing, down. Like any lighting out there that has to do with the cell
I
tower.
think you want to say maybe service lighting.
Mm-hmm.
Service lighting shall be aimed so as not to be visible outside the compound or something like that.
Mm.
But I think service lighting is the key because the reason that the lights exist is for the service of the equipment.
So service lighting shall be focused inside the enclosure and aimed at the ground. What was the additional verbiage you included, Mike?
I don't remember,
I think that was it.
to be honest. Was it maybe just that not visible from outside the compound or something like that? I don't know.
The whole point is just not to light up the neighbors, with something that keeps going on.
Yeah.
Not visible from outside the enclosure. All right, service lighting shall be focused inside the enclosure, aimed at the ground and not visible from outside of the enclosure,
What do you mean by enclosure?
the fence.
The ground, the
The
ground
compound.
enclosure.
The compound is probably a
Yeah, I
more,
don't, yeah, I think enclosure suggests there's some building there.
The equipment compound.
Yeah.
Well, someone, I mean, someone could see like a light. I don't know what visible means. It's-
Yeah, I mean, somebody could complain that they're seeing the light in between the slats in the wooden
Yeah,
fence.
yeah, I don't want to be too technical here.
Right.
Okay, service lighting shall be focused inside the equipment compound and aimed at the ground, so.
Yeah, can we
Yeah,
just
I-
leave it at
Leave it
that,
at that?
period? Yeah.
Okay,
Okay.
And
So
then,
that's,
Lori, I don't know if these are really conditions, but I think your decision will also just include that there's a 2-year lapse period
yeah,
to use the perm-
those are
to
the
use the special
standard
permit,
three.
and obviously that it.
Yeah.
Okay. Yeah, and then it has to be recorded, so those will be in there as well, but those are just consistent with, I think the board's familiar with those standard conditions, so
Correct.
I just wanted to
Yep,
mention them
those,
since we're going
those
through
three
all of
go
them.
on every decision.
Perfect. All right.
okay. So now those are all the conditions we've come up with so far. We've gone through the WCF bylaw, we went through the special permit site plan. We went through the waivers. It sounds like on the local level, the majority of board members would deny the waiver locally. So then we have to talk about the federal standards. Is that where we should go, Robin? At this point?
Yes, I mean, I think I think that you are from what you've said so far, it sounds like you're gonna need to reach the federal standards.
Mhm.
But ultimately, I do think you should vote under each somehow, so that you articulate your findings on each.
Okay. Well, I think we voted on the waivers. We were okay with the, do I have to make a motion to vote on the waivers, you think?
You haven't voted anything.
Right.
Right, we did a straw poll.
Well,
We need to do an actual motion.
yeah, I
And
mean, yeah, so I don't know, how you want to do it is a little bit up to the board, but ultimately, I think that you want to have a motion, for example, to approve the application as it's been discussed tonight and with all the details, strictly under your local bylaw.
Mhm.
And it sounds like that's probably going to fail. And then you should
Mhm.
articulate, each board member should say, these are the reasons I voted no. And then I think you should take a vote, once you conclude your discussion on the issue, to basically the same thing under under the Federal Telecommunications Act. And then give your reasons for whatever that vote is as well. And each of those motions should state that they're subject to the conditions that you just discussed. And like I said earlier, I think you're going to need to have some kind of third vote to essentially adopt so much of your draft decision that you circulate. I think everyone has seen the draft decision that Lori put together, as is consistent with the discussion tonight, and then authorizing a board member to work with Lori to finish writing it up, incorporate any changes from tonight's meeting, and get it filed, since it has to be filed, before Friday, right?
Before the 14th, I think it was. So can we say for
Yeah,
reasons
so this week.
discussed, because we did already go through the special permit site plan and I felt like we went through them one by one. And I guess, well, when
Yeah,
we
I mean,
talk about,
I think if folks feel like. So
we
if
get,
board members are, well, first of all, if you vote no under your bylaw, it's
Mhm.
critically important that you state all of the reasons. And so I know that people have made comments as you went, but if board members feel like there are more reasons that need to be stated, then I encourage you to state them. If people feel like you've already said everything you have to say in the discussion, then you can pull it out of for the reason stated and it'll get written up in the final decision.
I,
Um, but if anybody feels like, there's a reason they voted no that they haven't said yet, they should say it, if that's what they're doing.
I mean, I think I want to,
So, I mean,
be clear on some of my concerns on that is the fact that this is a scenic road and the elements of fitting in with the neighborhood and on the impact on that, in my mind, has a more significant bearing and meaning for I would say almost a protected um, clause or consideration. The scenic road designation is in place to protect views and enhance the enjoyment of all the people who travel through the area and live there. And the residents are definitely, impacted by a structure that is basically more than twice the size of anything that is anywhere nearby. It's within a large field. It's a massive amount of acreage, and then you have this huge field acreage, and then you have this, 135-foot structure that is going to be very, very obvious. I think it is in huge contrast to uh, you know, the visual terrain and what is the surrounding area.
Okay. And that's how
Plus,
you feel.
it's two scenic roads. It's at the crux of two scenic roads.
Mhm. Okay. For me, I feel like the same thing with the 130 feet is visually and aesthetically affecting the neighborhood. Um, and I think if you deny the waiver, then the special permit gets denied because the waiver was denied. And um, like I said before, I think it will adversely affect the neighborhood. I know there was evidence that from their um market analysis saying it wouldn't, but there's also the National Association of Realtors who says it would have an effect. Um, I feel that 130 feet is way above our bylaws for what is allowed there. And if I looked at our local bylaw level, I would be looking at just Northborough. So when I was looking at our special permit site plan, I was, looking at Northborough and how it's going to affect Northborough and that the location. I'm sorry, it's just getting so late. I feel like I've said it all already, but it went to the aesthetics and the height of the tower and how it will affect the neighborhood and that it is in a scenic area that, leads to the trails. All those reasons, um, it could be altered by bringing it down in size, but then that, like I said before, I'm denying it. for our local special permit bylaw. But mostly because, you know, of the waiver. But federally, I have to look at it a different way, so I'm sorry, it's just so late. But, yeah,
Anthony,
I
you want to
think-
go next?
I would just say, I'm just going right down the list here, it's not in substantial harmony with the master plan. The proposed site is not appropriate. Will adversely affect the neighborhood. So,
So I know I'm the only yes vote for this locally. And I'm just going to say that the reason for that, I agree with everything that the three of you has said. I believe, you know, scenic route is important, but I believe that the only thing more important than that is safety. And as somebody who lives in an area where there is no cell coverage, I know that if the power goes out of my house because of a fire, because of wires down, trees down, that's going to affect my family potentially, I want to be able to contact the fire department. I can't do that if I don't have a cell signal. We saw that on the very first night of testimony when there was a big storm and a lot of people were having trouble being able to call in on their cell phones. So for me, that's why this would be a yes. I agree that the scenic road idea is not great, but the only thing for me that could ever trump that is safety. So that's why I would vote yes.
Okay. So do we have to, so I have to make a motion? But then we also have to go through the federal criteria.
Yeah, do you want me to? Yeah, so you can continue your discussion and then just vote on both at once, or you could vote on the bylaw part now and then talk about the federal, however you want to do it.
Right. I think we should go through the federal just to get through all of it.
Sure.
So if we
And
look
then
through
Lori had suggested some motion language earlier that I played with. So when you're ready, I think between Lori and me, we can help with some motion suggestions.
Yeah, and it's tricky for me because if we're denying it locally but approving it federally, it's like we take two votes.
Yeah.
Yes.
Okay. And I think you
Yes.
and you had said before, if you deny it locally but approve it federally, then it's considered an approval. But if you deny it federally and
It
deny
is an
it,
approval, yes.
yeah, and if you deny it locally and deny it federally, then it's denial. Okay, I just want to make sure I have that
Lori's-
straight. Lori?
Lori's got her hand up. Yep.
I just wanted to remind you to close the public hearing before you vote.
I think Robin had said we could leave it open.
I mean, it technically, it's up to you. I mean, if you want to vote to close it or not. I mean, once you take your final vote on this, it's closed either way. So it's really up to you. You know,
think
and
we should leave
certainly
it
I don't want
open.
to open any kind of can of worms, like, you know, obviously, yeah, I mean, and obviously you're not taking any new input from the public or the applicant now, but I mean, if a member of the public just has a question about a condition, they certainly can ask it. I haven't heard anyone try. But, you know, this is really just the time for you guys to deliberate. And when you finally vote, it's closed. So you can vote to close it, but if you don't, it's okay.
Okay. I think after last time I closed it and then we needed to reopen it, that I should just leave it open for now.
Yeah, or you can vote to close it at the very end. It's fine. It doesn't really make a difference.
Okay. I think we should go through
So,
the federal criteria first, right? And then we'll do all the votes.
sure. And then you can just vote each. Yep, then you'll do all the votes.
So the first
Sure.
federal criteria, is significant gap. And I think we've talked about it, but for significant gap, how do people feel? Have they proved that there's a significant gap?
I think so.
Yeah, they've proved that there's a gap. I guess again, I'm gonna argue over the term significant, but there is a gap.
I feel after looking at the plots that I could, once I was, realized that I have to look at the whole gap and not just Northborough, that I can see that a significant gap was shown. Okay. Anthony, did you answer too?
I think I did.
Okay, I missed it. So, oh shoot. So the second part had to do with height. How do people feel? I think, or did we already talk about that? Like, I think we have to talk about it federally. For the local, I said I would deny the waiver for height, but federally, I feel like they showed that they needed it.
Yep, I agree.
Yep, they did.
Can you put the criteria up in front? Because I'm not sure where you are at.
Well, we don't even have it on a list, but I wrote it down. I have 4 different criteria, and maybe it's more, maybe Robin can tell us, but I have significant gap that we have to talk about, height we have to talk about, safety. Does it tower meet the safety standards, which is why I asked Mike about that. And then for some reason, the last one isn't on my page, but it has, feasible alternatives.
Is it the appropriate location? The
Is it
most
the
appropriate location?
I thought it was the appropriate project location or plan.
feasible alternatives?
Yeah.
Is that what it's called? Is
So
that how you
can I maybe just help with this?
Sure.
one?
Please.
Yep.
Do you want me, Amy, do you want me to help with this one?
Yes, that would be great.
Okay, so under the federal law, towns cannot apply their bylaws to effectively prohibit personal wireless services, and that includes tower companies building towers. Different courts look at what an effective prohibition means differently. So the federal court in Massachusetts, the First Circuit, has looked at an effective prohibition and talked to it in terms of what we call the First Circuit standard, which is there the significant coverage gap, and are there no feasible alternatives? Those are the two things. So if the applicant has demonstrated they need to provide the services because they're closing this gap and they can't do it in any other feasible, reasonable way, then if you apply your bylaw to say no, it is likely a court is going to say that was an effective prohibition. The FCC has issued some rulings with a different standard. It's called the materially inhibit standard, which in my opinion is even more favorable to carriers. There is a dispute amongst the courts whether or not we should be still applying that First Circuit standard or the material inhibit standard. The First Circuit courts haven't resolved that yet. Under the material inhibit standard, it's, in my opinion, it's somewhat similar, but a little bit more favorable to the carriers. It basically will say, is your decision materially inhibiting the provision of these services? Meaning, is your decision the reason these services can't be provided? And when courts look at that, they look at the need to provide new services and enhance services. And essentially, I think it's very similar to a feasible alternatives analysis. Is it your decision that's prohibiting the services? If there has nowhere else to go, then yes. So either way, and that's why I said this, like at a general high level standard earlier, if the applicant has demonstrated that they need to provide new or enhanced services and they really can't do it anywhere else in any other way, and they've demonstrated that to you, then I think they've met their standard under the federal law to have an approval. Because if not, you'll be effectively prohibiting the provision of the services. That's what it comes down to. And that's a decision the board has to make.
So if the criteria is based on height, safety, feasible alternatives, and one of the concerns that I have had through this is the due diligence with looking at other candidates. I have no communication, no actual data that supports they did that. does that fall under the feasible alternative investigation? I'm trying to figure out where something like that might apply, if it does.
Yeah, I mean, there's an argument that if the applicant has not demonstrated that they couldn't do this somewhere else that, say, wouldn't require the relief or wouldn't require the waivers or something, then maybe there is an alternative location. But we usually see that applied where there are actual alternative locations to point to identify, to say, here's 3 properties, we think are equally available. In the end, I can't say how a court is going to look if you simply just say, well, we don't think they gave us enough information to rule out potential alternatives, without specific ones in mind. But that's the standard. The standard is there somewhere else this could go? And, for example, would need waivers, or, I don't know that it helps if you say, we'll put it somewhere that still needs all the same waivers or more. But, I think the applicant has given you documentation about their due diligence. It's up to you, I guess, to decide if you think it's sufficient or not. I mean, it looks like Michael may have a comment as well, and I would, think you might want to hear from him as well, because he's looked at, the different possibilities that have been discussed. But, I think you have to make a decision at this point based on the record that you have. But if there aren't real alternative places to put this and you deny it, it's going to be very hard to defend.
Yeah, I mean, I think you captured it correctly, Robin, but the only thing I was going to add is you can't deny because there might be another alternative. You need to deny because there is another alternative. It might be doesn't meet the standard.
And so how would I have known what that alternative might have been?
Well, that, in some cases that alternative might be an existing tower that was unusable for some reason, or needed to be rebuilt, or needed something else, or some other way that a board could point to that you could say, well, applicant, if you went over there and we know you can go over there, you may need to do a bunch, it may be more costly, but it's certainly feasible. Then that's not a might, that's an is. Where if you're saying we think there is another location that would be better, that's a might be, because those applications haven't been vetted by either the applicant or by the board or by anybody really. So
right. That's my question about what due diligence actually is, vetting the alternatives to find out that they aren't applicable. And I feel that wasn't done. They contacted them, so they say, but they've never proven anything. And different places, even reciting it, I don't have any reason why they haven't given a reason why they couldn't put it somewhere else in that same property behind that stand of trees. But I've had some issues with how this application has, caused a lot of time constraints, and I'm trying to figure out why that becomes my problem, because I haven't had the time to, I mean, I'm not going to go and approach these properties and say, oh, by the way, would you consider a 135-foot cell tower? And they're going to say, why am I wasting time with you? Who else would be able to vet these properties except for the cell tower company?
Can I say something? I mean, I'm just,
Yeah.
well, I'm just saying, if we could have, we would have. I mean, if there's a better, easier site to permit, we would be there. I mean, we're here because there were no other sites. This is a obviously, challenging site, so we don't like to pick difficult sites. They're just, if they're the only one available, that's what we have to go with. So this isn't just, let's just pick one and go with it. It's a long drawn out process till we get to the one that seems to be the best one.
I don't know if this wasn't the first one that said yes, and you went with that and didn't bother really vetting out the other ones. I mean, I'm not sure what happened or how this happened.
No, we did give you other sites that we looked at and we ruled out, and that's the process. We have to look at sites, but if it doesn't work out, we just have to rule it out and move on, and that's what happened here. So
Didn't we ask?
Yeah.
Didn't we ask them to look at Ball Hill Road? And then there was a tall tower in Boylston. There were a couple places that we
There
looked
was, I
at.
did it very early on, when I looked at the tower database for existing tower facilities in the general vicinity of this proposal. One of the ones I found was the TV tower I think it's in Boylston. WUTF, I think is the call sign. And I asked the applicant to have their engineer run plots, and those plots are in the record. And that site is quite far south of the area that's shown in white and gray in the northern part of Boylston. So it didn't look like it was going to give the relief that was necessary. We also asked about some areas in Berlin, just over the border from Northborough. I think there were a couple of properties in Boylston that we also asked about, but the applicant came back and said that they were owned by the town of Boylston. And some of them were a good number of them were in conservation. And so therefore would be very difficult, if not impossible, to locate on. I think to go back to my point about there might be versus there is an alternative, in my view, the simple there is an alternative is there is something physical with height that could be an alternative. Clearly, there is nothing existing out in the section of Boylston, southwestern Berlin, and northwestern Northborough that we're talking about here, existing on the ground with the height that is necessary to provide the comparable coverage to what the proposal is providing. That I think everybody can agree on. There is no such thing. So the ask would be, could they locate this potential proposed tower somewhere else? And that opens up a lot more discretion and depth of analysis, because what property is, there's setbacks, there's ownership, there's conservation covenants, there's all kinds of things that can prevent a cell tower company from being able to use a particular parcel. And so it almost becomes the proverbial boiling of the ocean to try to rule out everything in an exhaustive way. But so there's going to be some kind of sampling here. That's all I can really say about it. I mean, I'm not sure you can point to 100 parcels and say you needed to contact 100 parcels and get a definitive no from all 100 of them. I don't think that's a reasonable standard.
No, I agree with you on that, but I'm not sure that contacting 3 of them shows.
Yeah, I mean,
that 4 is what they came down with. But again, I'm just struggling with that part of it.
I
Understood.
think, I think when I looked at it, they reached out to the three plus the two extras that, Mr. Lawton asked them to reach out to. I also looked around. I've noticed like some towns, when they go to deny, they see if there are any municipal properties around. So like I said earlier, I went to Green Street and I looked on the GIS map for Ball Street, Green Street, Smith Road, and all the municipal properties were in conservation restrictions. And then I did at one point go through the Boylston GIS, and a lot of those were in conservation restriction too. And I think what they said, the majority were conservation restriction and forestry.
Mhm.
And originally I thought, I could say, that it could go on small cells. That's where I started to, but I guess because it goes from Northborough to Boylston, we can't make Boylston do small cells. And they mentioned that the small cell antennas were too low and under the trees, so it would be an effective prohibition because it wouldn't do what they needed to do. And like Mr. Lawton just said, and I think Attorney Stein might have said, that if, at least in my opinion, what I heard was that if there's an alternative location, we have to have one to say, this is the alternative location you can use. We just can't say you have to go back out and find one. I don't think. I think that's what I heard. I'm just trying to, I, at least that's where I am in mine. Like, as much as I would love to, um, I don't know. I feel that this site too is at least back further than 351 Ball Street, and the whole west side of it is APR land. And even part of the east side is APR land. So yeah. So I feel like, I don't know, a lot of other sites were small in the area. I don't, that's just my personal feeling when I went and looked through it. And what I'm hearing is that I feel like, they're saying that, I don't know, that, that as much as I agree that we shouldn't have to go and look for space, I think that I can't point to a space that I feel would be a feasible location unless somebody came forward and had a piece of land and said, this one's open and I'm willing to lease it. And that's just where I stand, that I feel like that we've met the criteria for that, in my opinion, and for the significant gap.
Yep, I agree.
2.
Unfortunately, I'm not sure I do.
Are there any other questions you want to ask, like, or your definite AR decision?
I'm looking at this as this is a pretty important piece of property. It's a scenic road designation. I've gone back to that a couple of times. I feel that, I have to, I'm not happy about the position that this has put us in. I think it's a very difficult one. I will also point out the time constraints that we had in order to get all our answers, answers to our questions. I had asked specifically for some of the, you know, dates and things of contact and communication and details. I didn't get those. And I felt that that was a bit disappointing. I obviously, we're here to represent what the bylaws are in a town, but also the residents. And I feel that, I need to answer to the residents. And I do not feel that the applicant has done the most thorough job of basically looking at options and coming to a place where I feel like if the maximum height was 115 feet or 120 feet, that might be more agreeable. I don't think the 115 feet with the 20-foot extension was agreeable. I think the height was is higher than what this yeah, I'm gonna leave it at that.
Okay. My only concern is when I researched through tons of cases and everything is, and I'm not trying to sway you, but when we worked with the applicant, there were a lot of conditions like about screening the trees and sometimes and I don't know if I can even say this, but sometimes it could go to court and then we get no conditions. So I'm just concerned with that, but and I can't tell you how to vote or even sway you that way because maybe it wouldn't even go that far. But I think it's a little bit of a risk, but I don't know. I'm not trying to, I don't even know, Robin, if I can even say that. I'm just saying that because of my own, trying to look through towns and how do they, find an additional space. So I started reading about how towns did it, by using municipal land or finding someone else who came forward, but
I'm
Go ahead,
sorry.
Millie. Nope, go ahead.
Is the 115 feet the absolute minimum that would be accepted and be a you know a productive effort? I feel like the height of the tower is as much related not just to Verizon, but it's having to place 3 co-locators on it. And I feel like that's somewhat what's driving the request to override our bylaws.
Can I make a request, Amy, that we actually, I don't think anyone's going to change their vote at this time. So I would suggest we do the motion and get this over with.
yeah, and I shouldn't tell people how to vote and why, and I shouldn't have done that. So I was just,
We're all really tired.
right?
So
Okay.
let's do this and get it over with.
All right. So, should I make, I tried to write down motions, but should I make a motion to vote on the waivers first, or should we?
Do you want, and this is totally up to the board, but given what you said tonight, um, do you want to vote just the application under your bylaw and then the whole application under federal law, or do you want to take a site plan vote, a special permit vote, and waiver vote? Like, how do you want to do it?
Yeah, that's what I'm trying to figure out. That's where I got lost the last time when it got all confused, is because there's so many different ways to do that.
Well,
I
I
think-
mean, let me ask this question. No, go ahead. Sorry. I mean, I guess if no one on the board feels like they're going to vote differently on like a waiver versus site plan, you could vote it all together. If somebody thinks I'm going to vote one way under the bylaw on the site plan, but I'm going to vote a different way on the waivers, you can vote them all separately.
I actually had one more question. I know we don't want to extend the shot clock any further, but Millie, if you got the emails you were looking for, would that change your mind or no? Or
I would definitely have felt that they in fact did reach out and try to effectively communicate with people, get the answers, get denials, and get responses. And then I would feel very comfortable that they did in fact do that. It's just, I didn't think it was actually a lot to ask for. And I'm not sure, I find it odd that they say, oh, I went in and tried to talk to somebody who wasn't even the owner, they were the manager. I just found that to be very unconvincing that they almost did that after the fact. That
May
they,
I speak?
Yeah.
I'm sorry.
We do have some of the emails. I can forward them to you. It's just we put it into and the public hearing's closed. So,
Oh, no, we haven't closed the public hearing yet. And we
but no
actually have
more
a,
additional input. But I have the
Well,
emails, but we felt
yeah.
our alternate site analysis was sufficient because the person that did the work signed it and swore to it, and it's a testimony. So we have some emails. It's not a full record because it was two different people that did the site acquisition work over a span of 6 years.
Right, but they have some, they have the emails that were
I
actually
have
mentioned?
emails. I do not have every email.
No, but the ones that were mentioned, let's say Tugas Farm, no response to my email and phone inquiries. Wouldn't you think you'd follow up on that? They didn't even, it wasn't even the property owner. I mean,
I
that
have
doesn't
I
seem
have
like a big,
emails regarding Davidians, Tugas,
and Haven, and
and
nothing from Boylston, a phone call.
1, 2, 3, 4, 5 different, 6 different email exchanges. But we felt that our alternate site analysis covered everything because it just discussed everything that was in those emails, which isn't a lot, but we outlined it in that alternate site analysis.
Yeah, well, I guess, again, I don't want to drag this out too long, but I feel like I specifically asked 2 weeks ago for dates and for
Would you
emails, and I didn't get them.
would you like me to share my screen and I can show you
I
the
honestly think that
emails?
that seems a little bit, that you were at 11:30 at night, 5.5 hours into the meeting, and this was something I asked for, specifically emailed once, and again, I just, yeah, I mean, I don't know if I'll be able to actually process it the way I think I should, but what I was trying to really on make clear was that this that the emails really were a valid attempt to reach out and connect with the property.
Correct. And we testified that we made the attempts. We testified it. It's on the
I
record and
understand the
it's sworn
testify, but I'll be
testimony.
honest with you, the application has had a few, it's just had a few
I understand, Millie. I
data that's been
understand.
skewed
We have
in
the
your
emails.
favor, and I'm looking for actual
I
evidence.
understand. We based our alternate site analysis on the research that we did and on the analysis. We submitted it for testimony. But if you want to make the vote, you make the vote.
I have a suggestion too is, and I don't know if anyone will like this one, but we have a meeting tomorrow at 6 o'clock. If Millie, I don't know if she
Yeah.
emails you the emails, would you want to read
If
them?
it's
And we
not
just,
on,
if it's not what?
Amy,
Yeah.
if it's not on the agenda for if it's not on the agenda for the meeting tomorrow, you can't add it now.
Oh, we can't continue it. Can we continue it for, you'd have to have 48
No, I
hour
know, because you have
notice?
to post 48 hours. Yeah, so I mean, the earliest you really could meet on this again would be Thursday, which is cutting it really tight for your shot clock.
Well,
And at this point, if you are going to take more information, then you should plan to at least let the public comment on that, whatever new information you get.
would it
At
be worth it
Yeah.
to Millie and the applicant to do it on Thursday and open it up to comments? Like, I feel like we're so close to the end. And Millie,
Yeah,
you
I
said you
think
were,
we're ready. We don't want any more continuations. I mean,
yeah,
I think TowerCo is just, we provided the information via testimony. It's in your record. The emails, that's our background. That's what we do, but we don't generally offer emails between private people into a record because it just is not something that's done, which is why we put it in the alternate site analysis. And we outlined that and put it in the record and testified to it.
and do you agree, Mike Lawton, is that what you see in the alternate site analysis? You don't usually see emails, right? Or do you, or?
Um, not emails, descriptions of the process. You know, we contacted this person, contacted this person, contacted this person. And, you know, and not details, but not, I've not seen an application with, well, other than emails from the public, where a bunch of emails have been, part of the application or part of description of the, diligence for other locations.
Yeah, I just know that we can vote, but I do know as a board, if we do vote, it has to be something, you do want it to be something defensible, so I just, that's all I'm saying, and I guess it's 11:35, so if everybody's ready to take a vote, but definitely think long and hard and just be ready. Does anybody need a 5-minute break to stretch and think, or you're ready to go?
I'm ready to go.
Everybody's ready. You ready, Millie, you think? Or do you want to read the emails that she has? Like,
If-
I'm at this point, I
don't think she's-
the more I think
Okay.
about it, I don't want to share personal emails.
Right.
Sorry, or private emails. I have
Right.
them, 7 of them, but
and Mr. Lawton did say that this is usually that how they do it is with the site analysis list. But it's, you know, in the end, it's up to you. I'm not sure. Okay. So first, I'm going to take a vote on the waivers, and I think, do we have to take it? Oh, I'm sorry, just so late. Do you want me to, can I take a vote on the 2 waivers separately, or do you want me to, can you write up a motion that,
You can do whatever you want. I mean, I don't know if there are folks that would vote yes on one and no on the other. So, I mean, maybe you should just go through and vote.
see, I was hoping I
I
could
don't know.
vote.
Can you vote the 2 setback waivers in one vote and the height waiver in one vote?
So the
I mean, does
way
that
I
work
wrote
for-
them in the draft
I don't know if Lori, if Lori,
it kind of specifies that there are 2 separate ones. So because now the height of the tower is 115 feet, the setback would be 460 feet. So that no longer requires a waiver. So,
well, I think it's,
so what you would need is you would need the waiver from the 500-foot setback to the nearest residential structure. But that's all spelled out in the draft decision document that was emailed to both of you, the planning board and Robin.
so do you want to vote the setback waiver under the bylaw first?
Mhm.
Like you can just vote each thing. You can vote site plan under the bylaw, waiver 1 under the bylaw, waiver 2 under the bylaw. and then the special permit under the bylaw, and then do the same thing on the federal.
Okay. I don't even know how to say it.
Do you want me to just read it for
Yeah.
you?
But I think we should see, I'm just thinking the way I'm gonna vote. And I think everybody knows, like, I already said that locally, I was not gonna approve the waiver, but federally I was gonna approve it. So then do I vote no for special permit site plan, but then I vote yes federally? But I don't know how that motion would be made.
Okay,
So,
let me see if I can help. So without, I mean, just, is there any board member who is gonna vote differently on, for example, any of the waivers versus the special permit under the bylaw? Like, is there a reason, does any board member see a reason to not just take one vote that says the board moves to approve the application for site plan, setback and height waivers, and special permit under just the town's bylaw, subject to all the conditions? Like, is there anyone on the board that wants to vote separately on any of those things?
Not me.
Not me.
well, I knew that we all agreed on the setback and height bylaws, but just not on the height bylaw. So how do you vote that all
Okay.
in one? That's what I heard from the board earlier.
Well, that's what I'm asking. Is there any? Okay, so
So
that's
I
what,
would,
yeah, is there
uh-oh, you froze.
anybody who's gonna, for example, so you're gonna vote differently on the two waivers
Yes,
under the bylaw?
yes.
No, okay, so Amy, you're saying that you're gonna vote yes on one of the waivers and no on one of the waivers
Well, right, because
under the bylaw.
I had said earlier that if it was just our local bylaws looking at Northborough, I would vote no on the 130-foot waiver request. But looking at the federal regulations, I vote yes on the waiver. So I don't know how to word that for a decision.
But
And
what
then
about also for the site permit?
special permit site plan?
Yeah,
No, just, okay,
Well,
So
I
let-
was told that if you vote no on the waiver, then the special permit would also fail. But overall, I feel like they met the federal criteria. So I don't know how to do that easily. So I would vote yes federally, that I feel like they've met the
okay,
federal
but
criteria.
just, so you can take, yeah, so you, okay, sorry, there's like a delay with the sound on my end. I see your mouth move and then I don't hear it for a second, so I don't mean to interrupt. My question is, just under your local bylaw,
Mhm.
would you vote differently? Like, are you gonna approve some part of the application under the town's bylaw and disapprove some of it under the town's bylaw? Or is your vote on the town's bylaw just gonna be a straight up no?
Well, I felt that the majority of the criteria was okay, but there were just certain parts of it that were no. When we went through the special permit site planning conditions. Like, we went
Okay,
through
but
them one by
I'm just
one.
trying to help you with the vote here at
Yeah.
this point.
Right.
Okay, then let's do this. We're gonna have, well, but then I mean, do you want to take 8? Do you want to take 9 votes then, basically? So you can vote the site
think we're
plan
gonna
under the
have
local
to.
bylaw.
I think we're gonna have to, in a
You can
way.
vote each waiver and the special permit application, and then we'll do the same thing. Okay, that's fine. And then we'll do the same thing under the federal. Then we'll do the same thing under the federal. And then you're gonna need like one more motion to basically, because you've all seen your draft decision, And it's 11:43 at night, so unless you want to go through the entire draft decision, I think you can have a vote that says we've reviewed it and we are adopting the parts of the draft decision that are consistent with the discussion and the votes tonight. And then you're going to authorize, likely Amy, I guess, but that's up to you, to work with Lori and to have me review and write up the final decision with the discretion, just incorporate everything that was said tonight. So you're going to keep the parts that make sense to keep. You're going to add what needs to be added, and then you're going to get rid of the rest of it. So that would be a final vote. So if that makes sense, then, I think you can just say every one of these motions is going to be a motion in the affirmative that either passes or fails. And every one of these motions is subject to all the conditions that you already discussed. Right? So
Do I
if
have
it
to repeat
helps,
that?
I can just walk you through the motions.
Sure, that would help.
Okay, so you would have, what's that?
I didn't
Okay.
say anything.
Sorry, I don't know if you have the same sound delay on your end that I'm hearing the delay, but okay. So I think, and Lori, please jump in if I'm misstating anything, because obviously you know this application inside and out better than I do. But I think that you can have a motion to approve the application for, and so let me start. So you have a motion acting solely under the Town of Northborough zoning bylaw, not federal law, to approve for site plan approval for the proposed wireless facility, monopole, the tower at 110 feet. Hold on. This is making it difficult. Hold on. All right. So how about you do this? We'll say you're going to, let me strike that and I'll start again. How about a motion under the Town of Northborough zoning bylaw to grant the application for site plan approval for a communications tower for the construction and use of a 110-foot tall monopole with a 5-foot lightning rod for a total of 115 feet that will accommodate 9 panel antennas, 6 remote radio head units, and associated equipment with a 70-foot by 40-foot fence compound located at 409 Green Street, map 11, parcel 21, in the residential A zoning district, subject to the conditions of approval that were reviewed and approved at the board's meeting this evening. Lori, is that accurate?
Yeah, that seemed accurate to me.
Do I have to repeat it or can we say I agree with that motion? Motion to solely under the Town of
No, you
Northborough
just say
bylaw.
so moved.
So moved. So
Second.
this is, excuse me, is this just for the site plan approval? I just want to make sure. It's not special permit site plan, just site plan.
This is just site plan approval. Isn't it 2 different things under your bylaw?
Yes,
Isn't it a site plan approval and a special permit?
it can be special permit site plan all in one.
Okay, so we're gonna vote them separately then, so that everyone can vote however they want on each thing.
Yeah. Okay, so
Well,
this
do you
is
want to
for the-
vote them together or do you want to vote them separate?
separate. So this is a motion for the site plan approval for the
Okay,
monopole.
so there's a motion to approve the site plan,
Yeah, solely under the Northborough bylaw for 110 feet.
just under the local bylaw.
Yep. And it's been,
Okay. Yes.
someone said so moved. Is that Bill?
You said so moved and I said second.
Okay. So how do we vote? Who says? How do you vote? Since it's a roll call vote, since we're on Zoom,
You just need a
so
roll call vote.
yeah, Bill Pierce,
Aye.
Anthony Zaitin,
Anthony, you're muted.
No.
Millie Milton,
No.
and let's see. I'm looking at the criteria. I was a no because of the 130-foot pole didn't meet the scale in the building in the site. Okay, so 3 no's and 1 yes for the local only. Okay, so then we're going to do a motion solely under the town of Northborough bylaw for the special
Okay,
permit.
and to reiterate, the reasons that people are hold on. No, hold on. So, wait, to reiterate, the reasons that folks are voting no on this are the reasons that they've already stated, that they're already in the record, and those are gonna get incorporated in the decision, correct?
Mhm.
Okay, so I think you should do the waivers next, one at a time. So
Okay.
I think, again, and I'm just basing this off what Lori had sent earlier that I tweaked a little bit, but a motion acting solely under the town of Northborough zoning bylaw to grant the application for necessary setback waiver to construct the proposed communications tower with a 110-foot tall monopole with a 5-foot lightning rod on the property at 409 Green Street in the residential A zoning district, subject to the conditions of approval that have already been reviewed and approved by the meeting tonight. So this is for any necessary setback waiver.
For both setbacks. Okay, so moved.
Second,
Okay, roll call vote, Bill Pierce,
aye.
Anthony Zaitin,
Aye.
Millie Milton,
Aye.
and I'm an aye. Okay, so the motion for the waivers passed for the setbacks. So you won't have to retake that one.
Now you can do the height waiver and I'll essentially the same motion. Hold on, yeah. So the motion, sorry, I'm going back and forth between screens here. So this would be for the height waiver. So the motion under the town of Northborough zoning bylaw to grant the application for a height waiver necessary for the communication tower use for the construction and use of a 110-foot tall monopole with a 5-foot lightning rod on the real property at 409 Green Street in the Residence A district, subject to the conditions of approval that were reviewed and approved at the meeting tonight.
So moved.
Second,
Are we
Bill
doing the
Pierce?
waivers separately from state and fed?
Yeah, this is
Yes.
this local.
Okay.
aye.
No.
Anthony Zaitin.
Yeah, we're gonna do, this is just under the local bylaw, so all the votes right now under
Right.
local.
No.
Anthony Zaitin, no. Millie Milton
No.
and Amy Pertzke's a no. So now we go to special permit under the solely under Northborough bylaw.
Yep, give me 1 second. Hold on. Yep, hold on 1 second. And just to confirm again, the basis for the denial are all of the reasons you've already articulated about height and aesthetics and property values and all of those things that are going to get incorporated in the decision. Okay.
Yep.
All right, so the last, under just the town of Northborough zoning bylaw, to grant the application for a special permit for a communication tower use for the construction and use of a 110-foot tall monopole with a 5-foot lightning rod for a total of 115 feet that will accommodate 9 panel antennas, 6 remote radio heads, and associated equipment within a 70-foot by 70-foot fenced compound located at 409 Green Street in the Residence A zoning district, subject to the conditions of approval reviewed and approved at the meeting tonight. So this
So
is the
moved.
special permit just under your local bylaw.
Second,
Right, for all the reasons that we discussed earlier. Motion approved and seconded. Roll call vote. Bill Pierce.
aye.
You gotta
Anthony
vote
Zaitin.
it.
What?
No.
Millie Milton
No.
And I'm a no. Okay, so they failed locally. But now we go through them federal?
Okay. And just to clarify, in addition to what you've already articulated, because the waivers were not. Yep, and just to clarify, in addition to everything you've already articulated, without the waivers, this doesn't qualify, I take it, for the special permit?
Yeah, I
Okay,
had
so
stated that.
we'll add that. All right, so now, and it's up to you guys, from your discussion, I don't know if it's necessary to go through. Yep, okay. And so from your discussion previously, I don't know if it's necessary to take 4 votes. It's up to you. Or if you're comfortable to take 1 vote, that is just a motion to approve so much of the application for the special permit and site plan approval with waivers for the 110-foot tall monopole with a 5-foot lightning rod that will accommodate 9 panel antenna, 6 remote radio head units and associated equipment within a 70 by 70 foot fence compound located at 409 Green Street in the residential zoning district under the Federal Telecommunications Act, which has not already been approved by the board. So are you comfortable to take 1 motion?
And then we just say subject to conditions of approval.
Basically to approve on site plan, special permit, and the height waiver, which are the things you haven't already granted.
And this is subject to
Yes,
conditions of
But
approval.
are you comfortable to take 1 vote on that, or do you want to take 4 separate votes
I'm comfortable with 1.
Me too.
that you've already discussed? Yes, so you would be voting.
Millie, do you want to break it out or do you want to take 1 vote?
It doesn't
Amy, are
matter.
you comfortable with 1 vote?
Sure, I'm comfortable with 1 vote. Can you hear me?
Yeah, she's got a delay, so you got to give her a minute.
Okay, then
Oh,
you
I
can
didn't know.
have a motion acting. Yep, can you hear me?
Yeah.
Sorry. Yeah, then you can have a motion acting under the Federal Telecommunications Act to grant the application for a special permit, including the requested height waiver and site plan approval for a communication tower use for the construction of a 110-foot tall monopole with 5-foot lightning rod for a total of 115 feet that will accommodate 9 panel antennas, 6 remote radio head units, and associated equipment within a 70 by 70 foot fence compound located at 409 Green Street, map 11, parcel 21 in the residential zoning district, subject to the conditions of approval that the board reviewed and approved tonight, understanding that the board has already approved the setback waiver under the local bylaw.
Mm-hmm. Okay, so moved.
Second.
Is there anything
Does
else?
that capture
Anybody?
everything, Lori? Okay.
Is there anything anybody else wants to discuss before we vote? So this is for all the reasons we stated earlier. Okay. So roll call vote, Bill Pierce.
Aye.
So this is under the TCA.
This is under the federal. Anthony Zaitin,
Aye.
Millie Milton,
No.
and I'm an I.
Yes.
So that's 3-1. Federally.
Yep.
So that fails. Yes. So Millie, for purposes of the decision, where you're the no vote, do you want it simply to include that you don't believe the applicant demonstrated there were no feasible alternatives consistent with your comments, or is there anything additional you want to see in the decision?
I guess if I was supposed to come up with alternative lots or plans, I would have done that. I felt that there, again, I made it clear that even moving it to the other side of the trees wasn't demonstrated to me why it couldn't be done. I'm just not convinced that I have proof that there was things really investigated.
Okay. So then I think
Okay.
that given the timing and everything else, and I already said this a couple times, but it would make sense to have a motion. Can you hear me?
Yes.
Yep.
Yeah,
Okay, sorry. It would make sense to have a motion to adopt the findings contained in the board's draft decision that are consistent with your aforesaid votes, consistent with your comments this evening, and to adopt the additional findings and reasons that you've stated during your break-ins, and then authorize, and you pick, I'm assuming Amy, but you pick somebody, Tori, and let me review it to get the final decision drafted and filed this week.
Okay. Millie, since you were the no vote, do you want to review the decision? Or you don't, or you want me to, or Bill, or Anthony?
I'm not sure really what that entails at this point.
Lori's written almost the whole decision. You just have to review the findings of fact and
Okay.
and you have to, I mean, I can review them too, but I think I've
I mean,
reviewed
it's
most of
going to
it.
need revision based on,
Right. I've reviewed most of it, so should more than one person read it, or Millie, if you want to do it, you can do it. You just have to make sure the findings of
it's
fact are there.
Sorry, people are cutting
I
out.
think Lori has a question.
Yeah, when it comes to the findings of fact, so I know that Millie voted no, but what if she's the only one who supports a specific finding and everybody else doesn't agree with it? So does that finding go into the findings of facts, or am I including findings that are like the majority of the board?
Or can you do like,
So I think and I can help you, Lori, when it comes to writing it up, but I think you can just say that the dissenting member, the member that voted no, gave these reasons. So I can help you with where to put it in the structure.
Okay.
But I think at least one board member needs to be appointed to work with you to give this a final review and get it filed. I mean, I take it you're not going to meet again on Thursday to review the draft decision, right?
no, we do have a meeting tomorrow, but I don't mind reading it because I've read it a couple
But again,
times.
it's not likely to be ready by tomorrow, and
Yep.
it's up to you guys. I just highly recommend that you appoint a board member so that you have a board member who's looking, Lori's going to put it together. I'll give it a review, but a board member should, in my opinion, give it a final read for filing. The board should authorize a board member to, unless you're going to meet again on Thursday to actually approve the decision. Those are your two choices.
Is that the only way to let all board members read it, or can all board members read it? Can Lori like draft it up and can all board members read it?
Yes.
Okay, so then maybe we all read it.
No.
No.
The only way under the open meeting law, the only way under the open meeting law for board members to contribute to writing the decision is if Lori puts it together with me and then we send it out to all of you and you hold another meeting on Thursday to review and finalize the decision as a group in a public meeting.
Is that what
If
the board
not,
members want to do?
the board should authorize a board member to have the authority. It's up to you guys. It's
Yeah.
one or the other. It's up to you.
I can't meet on Thursday.
Millie, do you have time to review it with Lori?
When do we have to have this done by?
The 14th.
By the 14th? Okay. I will make time.
Yeah, if you want to, just because because she was the one who voted no, doesn't it really hinge on her reading it, or should I read it? It doesn't matter. Because I'm the chair, it doesn't matter.
It's up to you. I mean, you both could, you could have two of you, because that's fine, but
Okay.
again, it's can you, timing wise, it's really up to you guys. But your shot clock runs on Friday. I will tell you, I don't have availability on Friday, so I'd like to be able to get my comments back to you, and essentially, I think you should be shooting the file out on Thursday. So it's just up to you guys how you want to do it.
I can make something work tomorrow or Wednesday.
Okay, we can appoint both of us in case she can't make it work, then I'll read it with Lori. If two people can read it. I'll leave it to Millie, but if
Yeah,
Millie
so
can't for some
the
reason,
motion-
I'll read it.
Okay, does that work for the whole board?
Yep.
Yeah.
To have Millie and or Amy work with Lori and I'll review it and you guys will get it filed?
Sure.
Mhm.
So do I have to
Okay.
make a motion?
So you can have a so moved on that as well.
So moved. Roll call vote.
Second.
I mean, I can make, you want me to say it again?
Sure. I think she's frozen.
Mhm.
Nope, she's moving.
No, I'm not. I can hear you.
Okay.
No, I can hear. I thought you said you had a second, right?
Yeah, I thought we did.
Oh, okay. I thought you were
So you just
redoing
need
it.
a roll call vote.
Nope.
Roll call vote. Bill Pierce,
Aye.
Anthony Zine,
Aye.
Oh, did you
Millie
want me to read it
Milton.
again?
Aye.
and I'm an
Okay.
aye. Okay. So we'll get that decision done.
Well, then, for completeness, you certainly could,
Close the hearing.
yeah, and if it's for completeness and if it's your practice, you can certainly, take a motion to close the public hearing. Yeah.
I make a motion to close the public hearing. I got that one down.
Second.
Bill Pierce,
Aye.
Anthony Zaitin,
Aye.
Millie Milton,
Aye.
and I'm an aye. Okay. Can I make a motion to close the whole meeting? Sorry, it's so late.
Yeah. Do we need to go through the rest of the agenda items?
I don't think so. We
No,
meet
this
again
one's done.
tomorrow.
Night,
Yeah.
everyone.
Close it
Thank
up.
you.
All right, thank
Right,
you.
wait, I have to make a motion to close the hearing.
Yeah,
I mean, close the meeting.
just for us.
Yeah,
Everyone
just
else
for
can
us.
leave.
Do I have a motion to close the meeting? Hearing
So moved.
or to
Second.
adjourn?
Yeah, to adjourn.
To adjourn. All right. There was a first and a second. Bill Pierce,
Aye.
Anthony Zaitin. Anthony, you don't want to go?
Aye.
Just kidding. Millie Milton,
Aye.
and I'm an aye. All
Good night,
right.
everyone. See you
Good
tomorrow.
night. Good night.
Good night.
Bye.
Night.
Thank you.